Good afternoon. Welcome to the Appellate Division First Department. Oral arguments for today, March 30th, 2021. People versus Tony Rivera, submitted. Hedinger versus Amchem Products. Respondent? I'm sorry, appellant?
Present. Linda Clark, Barclay
Six-
Damon.
6 minutes. Respondent?
Yes, please, with one reserved, if I may.
So it's 5 and 1 for the appellant. And I'm sorry, respondent?
6 minutes, please, Your Honor.
Yes. Matter of Sarah versus Aubrey S. submitted. Chartery versus 3511 Systems submitted. Ben v. Beacon Capital submitted. People versus Maurice Hennigan submitted. Ma versus 40-44 West 120th Street.
Appellant Michael Furman. Good afternoon, Your Honor. I'll make myself available for questions. If not, I'm happy to submit.
Ideal Media versus, well, before we do that, on Ma, any of the members of the panel have any questions? So that Mr. Furman doesn't have to stay throughout the calendar?
I don't mind.
Oh, you don't mind? Okay.
I'm not going anywhere.
I have no questions.
Any questions, Justice Kern? Justice
Then I'll
White?
leave you.
No. So, Mr. Furman, if you just want to stay and watch, you can certainly do so. But we, nothing personal, but we don't need you.
I got it. Be well, everyone. Good to see everyone.
Submitted. Thank you. Ideal Media versus Barron.
Appellant, Your Honor, if I may have 1 minute for rebuttal.
Certainly. 5 and 1. Respondent?
Eric Wertheim for respondent. I'm fine with my allotted 6 minutes.
Thank you. Jimenez versus Greyhound Lines. Submitted. Crack versus New York City Health and Hospitals. Submitted. People versus Johnny Capellas. Submitted. International Franchise versus City of New York.
Good afternoon, Your Honor. Appellant here for International Franchise Association. We request 2 minutes for rebuttal, please.
Yes, that's 6 and 2.
Yeah.
Yes, we have
Yes,
two.
Your Honor. Yes, Your Honor.
Yes, we have 2 respondents.
Ingrid Gustafson, Your Honor, on behalf of the respondent city.
6 minutes.
Thank you.
And
For the individual defendant respondents, James Reef, 6 minutes.
yes, thank you. Salomon versus EIP Global Fund.
Good afternoon, Your Honor. Appellant requests 6 and 2.
Yes. Respondent.
Good afternoon, Your Honor. I'm fine with my 8 minutes.
Thank you. Who do we have? Girandola versus Shea.
Good afternoon, Your Honor. Peter Tillum, may I have 2 minutes on rebuttal?
Yes, that's 5 and 2.
Thank you.
Clay Henry on behalf of respondents.
5 minutes. Almeida versus Concourse Rehabilitation.
Shannon Henderson on behalf of appellant. May I please reserve a minute for rebuttal?
4 and 1. Respondent.
Good afternoon, Your Honor. This is Evan Bain of Wrestler & Wrestler, the sponsoring law firm. Yes, Your Honor. Thank you.
You're welcome. Salzano versus Air and Liquid.
Nicholas Hersler for the appellant. I'm fine with 7 and 2, Your Honor.
7 minutes for the respondent, please, Your Honor.
Yes, please everyone mute, place your microphones on mute because we're getting somewhat of a feedback here. People versus Christopher Rodriguez.
Good afternoon, Your Honor. Jake Walter Warner for Christopher Rodriguez. We'd like to request just 1 minute for rebuttal.
5 and 1.
Thank you.
People.
Good afternoon, Your Honor. Michael Yetter for the people, and we're happy with our allotted time. Thank you.
6 minutes. Robinson versus Great Performances.
Yes, Your Honor. Lois Traub, Eleanor Grossman and Scholl for great performances. The appellant, we request 8 minutes and 2 for rebuttal.
Yes. Respondent?
Eric Milner of Simon & Milner, appearing for the respondent, and I'm fine with the 8 minutes that was allotted.
Thank you. Vega versus the City of New York?
Jameson Davies for the City of New York. I'd like to request 1 minute for rebuttal, please.
4 and 1.
And on behalf of respondent Thomas Tilly, I'm fine with my allotted time. Thank you.
5 minutes. Thank you. So again, please keep your mics muted unless you are actually speaking. Also, do not speak over the justices. And we will proceed then with the first case for argument, Hettinger versus Amchem Products. Whenever you're ready.
Thank you. May it please the court. Good afternoon, Your Honors. This is Linda Clark from Barclay Damon for the appellant P&H Mining. Your Honors, unlike many of the other cases on your calendar this afternoon, this is not a case that has ever been addressed in any fashion on the merits. But it is a case that lacks merit. In fact, it's a case where there's undisputed evidence in the record in this asbestos case that plaintiff could not have ever been exposed to any asbestos from the appellant's products.
Counsel, before we start the merits, why don't you address the issue of whether or not the motion was timely and whether the court below correctly denied it as untimely, since that's the issue that's before us.
Of course, Your Honor. In this case, we have a situation where we were not following the CPLR, but rather we were following the provisions of the case management order that applies to the asbestos cases under the NICAL rules.
Counsel, isn't that permissible? Didn't this department issue a decision in 2008 in reference to all asbestos litigation, saying that the procedural protocols of the CMOs are valid even when they don't strictly conform to the CPLR? How do you get around this?
So, Your Honor, we do not dispute that the CMO applies to the situation. Frankly, the CMO plus the judge's own part rules, which were consulted. I'm only making the point that unlike the CPLR, which has different nomenclature as decided under the Brill case that's relied upon by the respondents, in this situation, we were dealing with the language of the CPLR itself, plus the judge's own part rules.
Counsel, this is Judge Kern. Why should we reject the court's own understanding of what a trial date means, which is a trial date that's set by the court as a trial date, as opposed to your interpretation, which was the time it actually gets sent out, since that's an ever-shifting date, and there would never then be any certainty as to what the date would be.
Sure, and the reason for that, Your Honor, is that when the appellant made the motion, it was backing out and making some calculations based upon its understanding objectively of when the motion could and should be due. Certainly, there was no understanding that the date, the 25th, was an actual true trial date. In all respects, that date was properly viewed as a trial-ready date. And that is exactly what is referred to.
But counsel, as Justice Kern just stated, it would be ever shifting. We would never have a definite trial date. I mean, we're talking about trial ready, and what was stated was that it was on the trial calendar. So how would you, I'm not really sure how your argument would work in the real world of trial ready cases.
Sure. Well, Your Honor, in the asbestos cases, when you get a trial ready date, it's then assigned a trial. The CMO provision we're talking about, which is section 21 of the CMO, it has a provision that would deal with that eventuality where there's less than 30 days before the actual trial date. It gives
okay, so if the trial ready date was set for March 30th, under your theory. So here it is, March 30th now, and the case is adjourned to a trial part for tomorrow, March 31st. When would the 30-day period have run?
Well, in that situation, Your Honor, I think the court would have the ability to make other arrangements and a scheduling order specific to that kind of a scenario. But in this situation, all the appellant did was file the motion 30 days, without even having a firm trial date in advance in anticipation of the trial date, thinking that the court would, of course, set an appropriate date at that meeting for hearing of the
Counsel,
summary judgment motion.
isn't your response somewhat convoluted in the sense that trial ready really means trial date? Trial ready means the case is ready to go out and be tried that day, be it in that part or in another part. Here we have a judge issuing an order and then interpreting what his order meant as far as trial ready goes, and you're saying, no, he didn't really know what he was writing or interpreting?
Sure, Your Honor. And, we're not really disputing that the trial judge interpreted his order that way. What we're saying that is objectively, in terms of reading his part rules in conjunction with the CMO, which are really quite different than the CPLR rule that was decided in the Brill case. We're distinguishing that situation because the CMO and the asbestos cases are handled very differently. There was no anticipation on this date that this was a true trial date. There hadn't even been a trial judge assigned at this point.
I think the anticipation was from the judge who set that down as the trial date. But anyhow, you have a minute on rebuttal. Respondent?
Thank you, Jason Weinstein, Weitz and Luxembourg, for the respondents. Your Honors, what we had here was Justice Mendez as the supervising judge of NICAL interpreting his own order, setting forth the trial date of this case, setting forth his own interpretation of the NICAL CMO, and setting forth his own interpretation of his court rules, all of which the defendant seems to have a different interpretation of. And accordingly, Justice Mendez properly decided that the summary judgment motion made in this case, which came about 3 years after the deposition took place, and the defendant could have made the motion, was untimely, as it was made.
Counsel, you say it was Justice Mendez's interpretation, where it may be his interpretation, but that interpretation cannot be arbitrary, nor can that interpretation be contrary to what the rules actually anticipate. So is it only his interpretation that should be guiding us?
No, Your Honor, except with respect to his own part rules. I believe that Justice Mendez was entitled to properly interpret his own part rules, which the defendant appears to have a different interpretation of here than Justice Mendez himself. With respect to the NICAL CMO, it was a perfectly ordinary interpretation and objectively correct. The NICAL CMO specifically states that no summary judgment motion should be made within 30 days of the trial date. And the trial date for this case, as set forth in Justice Mendez's order, was 8 days away from when the summary judgment motion was made. It's really that simple.
Any other questions? Any questions? No? Thank you very much, counsel. Yes, Ms. Clark?
So, Your Honor, even if we went to the Brill case and some of the other cases cited, in this situation, even the opposition to the motion itself was belated. So the court really should not have even considered the opposition raising the untimeliness of the motion without giving us an opportunity to reply and set forth the reasonable excuse for the delay under Brill.
Judge Crum, why did the court even need the opposition to address the issue? Though the court has the authority on its own, even without any opposition papers, to reject a motion as untimely under its own rules.
I think it does have that authority, Your Honor, but the cases that we cited in the brief suggested that if the opposition itself is untimely, then on that basis alone, the motion should be granted rather than denied. At a minimum, Your Honor, we should have at least had an opportunity to reply here and offer the reasonable excuse for the late filing of the motion. And in fact, that was the reason we believe that the whole case was adjourned to 3/31. And then out of the blue on 3/25, we got this sua sponte decision from the judge before we even had a chance to appear before the court again on 3/31. Now, admittedly, in March of last year, there was a lot going on, but the whole trajectory of this case, which is now denied any adjudication on the merits, given the confusion between the part rules, the provisions of the CMO, and the intervening adjustment of the dates, which really would have cured the 30-day problem. And then the issuance of the decision a week before we were supposed to reconvene on the trial ready date, all really calls out for at least the opportunity for this motion to be heard, given the real lack of any effort to establish any merit at all.
Thank you very much, counsel.
Thank you, Your Honors.
Before we proceed, as was pointed out by my colleague, I failed to call the last two cases on the calendar, which was Little and Robinson versus Willman, which was submitted, and Tawa versus McNiff, which was also submitted. Next case on for argument is Ideal Media versus Barron.
Good afternoon, Your Honor. Jose Baez for appellant, Alexander Barron, and retiree. Your Honor, this is the case, an appeal from a summary judgment that was granted. Your Honor, the very essence of a motion for summary judgment is that the movement was established by admissible evidence that there are no issues with disputed fact for the trier of fact to determine. Any inferences go to the non-moving party. Here, the lower court should have never granted summary judgment because every material issue of fact is in dispute. For instance,
Counsel,
the
don't
payment
you
of
have, Counsel, if I may, this is Judge Gonzalez. Aren't there several admissions that would allow in the record that would allow the court to reach the issue of summary judgment, to grant it? Don't you have, isn't the issue here the withdrawal of $95,000 without alleged authorization from the plaintiff's account? And in this case, don't you have various statements such as the $95,000 is the first part of my settlements, and then later on a question, then you transferred the money out? No, I transferred it out so I can process it, because what if you took that away also like you took away my email? And then isn't there an apology? I just want to tell you guys I'm sorry. I acted in the worst way possible. Aren't those admissions of which the court can take note?
But this is the problem that I agree, you are respectfully. In conjunction with those words, Mr. Barron testified that the owner, Victor Renshaw, approved the payment, whether it was a transfer or a payment or servants or settlement. Mr. Renshaw approved those payments. They have not submitted any evidence to the contrary. And we tried to depose Mr. Renshaw, who was the owner, on this issue. The night before the deposition, they told us, well, we're not producing him because he's not really an employee of the company, he's an owner. Well, that's splitting hairs, but they didn't produce him. Then we tried to hire an investigator to find Mr. Renshaw. They went to his house, they told us he was in Russia. And then we went to his office. And the security won't let us up to serve him. A few days later, they served a note of issue on us. But all those references Your Honor is mentioning, Justice Gonzalez, all the payments were approved by Mr. Renshaw at page 316, page 317, page 329, page 331, page 357, page 359, and pages 395 to 96. In all those instances, he testified that Mr. Renshaw approved the payment prior to the payment, and they have not rebutted that particular issue. So while the court may have taken liberty with it, the code below, the fact is that they never rebutted that. They may submit an affidavit from Mr. Renshaw or anyone else that Mr. Renshaw did not approve the payment. They did not. So that's where we stand at, on that issue. Another issue that's in dispute is the timing of the transfer. When was the transfer? My client testified that the payment was made before he was fired. They claimed that he was that the transfer was made after he was fired, right? And then another issue is the firing. When he was fired, he claims he was fired 2 or 3 days after the 26th. They claiming he was fired the 25th of March. So those are issues that are in dispute. Those are material issues to this case. On the contract issue, my client testified, unrebutted, that there were 4 contracts there. We asked for the contracts. They produced 1 contract, the one that was convenient for them for $24,000. The rest they didn't. They didn't say they didn't exist. They said the contracts, we did a research, we cannot find the contracts. That's what they said. They did not deny that they existed, merely that we can find it. Now, here's the problem with that. They didn't tell us who conducted the search, where was the search conducted, what methods or tools they used to conduct that search. But nonetheless, they still did not deny the existence of those contracts, just that they couldn't find them. And that's the issue here, Your Honor. Also, the terms of the contract is in dispute. Here's the issue. My client testified under oath that the contract was to expire at the end of 2019. Yet, they're claiming that they expired before that. But we don't have the contracts because they refused to produce them. Let me, if I may, lay a little bit of context here. My client was sent to a conference by the company in Vail, Colorado. The moment he lands in Vail, they raided his office. They took away his emails, took away all his documents, and then they don't come back, and then let him into the office. And that's why they don't have, we don't have the contracts. They have the contracts, but they refuse to produce them. So those are issues that are in dispute and cannot be reconciled by them. Now, they submitted a bunch of documents in reply that some of them appears that they had before the summary judgment, but those are new evidence that should have never been considered by the court below. So for those issues, Your Honor, that part of the summary judgment should be vacated. On the note of issue, they submitted a note of issue 2 months before the end of discovery. On May 9th, discovery was supposed to end July 31st. They did not wait. They found out we were looking after for Mr. Rencha. They filed the notice. In the note of issue, they stated that we waived discovery. Not true. In the note of issue, they said that we waived the jury trial. Not true. And also, they failed to mention our counterclaims in there. So
what was the outstanding? I'm sorry, counsel. What was the outstanding discovery? You're talking about all of these contracts. That was the outstanding discovery.
Not only that, but we're trying to reach Mr. Rencha to depose him as a brother who actually owned the company.
I see. Thank you. You have a minute on rebuttal. Respondent?
Yes, Eric Wertheim for respondent. Let me start with the point I intended to make, and then I'll just address a couple of things that Mr. Baez said. You may be aware, first of all, there are 2 distinct legal theories as to why Mr. Barron's withdrawal of the $95,000 was wrongful. One has to do with, yes, you were put on notice that you were being terminated, and it's very clear from the chat that was part of our initial motion papers that he did know. There was nothing equivocal or prospective about it. But the second point is, even if you were still the CEO and you weren't terminated, you can't say, I'm owed $95,000, so I'm going to take all the money and leave $1,600 in the bank account when the company then can't pay its employees and bills. Okay, it's a distinct legal concept that we made in our original motion. It was discussed. The judge, actually, the motion judge, was more focused on that theory than the issue of when he was terminated. Appellants have never addressed that legal issue at all. There is not one word of it in any of their papers, either at the trial level or the appeal level. Interestingly, the only thing they say about it is in their reply brief, there's a sentence to the effect that we didn't preserve the issue because we supposedly did not argue it in the court below. Now, of course, in the record on appeal, our memoranda of law was not included because it's usually not included. Their legal arguments were included because it came in the form of an attorney affirmation, which attorneys still do sometimes. Their affirmation is effectively the legal memorandum. If their mere assertion in the reply brief, without support, saying that we didn't argue it below, I am asking the court today to take judicial notice of the docket entries of our motion papers, because we did argue it. In e-courts, you will see in entry 79, docket entry 79 is our initial memorandum of law. We say, I'm quoting from it, just a sentence, because Barron nearly emptied plaintiff's bank account at a time when plaintiff admittedly owed substantial sums to creditors and employees. The resultant insolvency of plaintiff further reinforces Barron's liability for breach of fiduciary duty. So we made the argument in their opposition papers, and like everywhere else in the record in this case, they say nothing about it. And in our reply memorandum in docket 103, we point that out. It's just a list of arguments that they didn't address in opposition to summary judgment.
Counsel, this is Judge. Counsel, this is Judge Gonzalez, if I may.
Yes.
Your adversary argues that there was interference with taking the deposition of Mr. Denyasenko. Can you respond to that? Because my understanding is that there were no depositions, there was no request for further documents, and no additional parties were impleaded. But that's different from saying that the plaintiff obstructed or made impossible the deposition of the director of the plaintiff's parent company.
Right. Okay. I think we make clear, the record is very clear in our papers, that we begged opposing counsel to take the party depositions. The idea that there was a fight or an impasse or resistance, frankly, I don't want to be disrespectful. It's made up, because there was one side. It's a bizarre situation because there's one-sided communications in writing between the parties about the depositions they were to take. My associate, Daniel Axelrod, you will see his name and his emails in the record, kept writing to Mr. Baez saying, take the depositions, take the depositions. There's no fight. There's no record of any resistance to producing anybody for a deposition except these remshahs, which is like a central part of their story in the case. Right at the very beginning of the case, they sent us deposition notices. They're not framed as like party deposition notices where it says, I deal by these guys. But we, out of caution, we wrote to him and we said, this is long ago at the beginning of the case. We wrote to counsel saying, listen, we don't control these people. We're not producing them. Go find them. Great. Or go seek the court's help in finding an alternative way to get them served if you're having difficulty serving. They did nothing. Absolutely nothing. We never heard from them. They are not on record with us as saying, oh, yes, you do control these people. It just never came up. None of this came up.
And counsel, you only have 1 minute left, but to that point, what about your adversary's argument that you also did not produce the documentary evidence, specifically these contracts that he referred to?
And we deal with that in the papers, and the idea, and frankly, it's a little insulting, the idea that we resisted or refused is absolutely false. At the deposition, we both agreed, the subject came up of these non-executed contracts, and Mr. Baez and I both said, we'll go look for them. We looked for them. We don't have them. My client looked for them and put part of his affidavit says, look, we looked for this stuff. We can't find it. This is what happened. Listen, I've been in a lot of cases where you suspect maybe the party is or is not looking for things. You got to take a custodian of records deposition. You can't just come into court and say the other side is lying when it says it doesn't have documents. That's the central point here is there's no fight. There was no impasse about it. We told our clients to look for it. They said they looked for it. They don't have it. If they found contracts, whether they were the same, the bilaterally signed, unilaterally signed, unsigned, we would have produced them. It's just like with the depositions of the remshahs. The idea that there was an impasse or some active problem only came up after we filed the note of issue, long after these issues were discussed.
Thank you,
It's
counsel.
just real.
Thank you. Your time is up. Mr. Baez, you have 1 minute.
Yeah, Your Honor, thank you. Your Honor, just let me go back to the Renchas. They own the company. Victor and Dima Rencha own the company. We noticed that the positions are for the company. They refused to produce them. It was
So, counsel, when I asked your adversary about Mr. Denyusenko, I really should have been asking him about Mr. Renshaw, but you didn't try to take Mr. Denyusenko's deposition either, right?
That's right.
Or anyone's deposition other than Mr. Renshaw, is that right?
That's right, because our client testified for 9 hours that he only dealt with the Renchas brothers. Now, Denyusenko is a person based in Kiev, the Ukraine. My client never dealt with him running the company. My client ran the company with Mr. The Renchas, not with Denyusenko.
Mr. Denyusenko is the person who advised your client one day ahead of time that he was going to be terminated, and the emails acknowledging the $95,000 transfer went to Mr. Denyusenko, right?
That's correct. And in that context, also my client tells him that Victor Rencha approved the payments. They never have rebutted that. But in that instance, as my client testified also, he had no reason to take orders from Mr. Denyusenko because Mr. Denyusenko just appeared on the scene from nowhere and started giving orders. So my client had no reason to listen to Denyusenko or anyone else except the Renchas. This is what they're claiming now. The issue of the transfer, they keep claiming that the payment was not approved. It was approved by the Renchas, and I cited to the record a number of times where my client testified, again, for the record, 316.
Thank you, counsel. Mr. Baez, your time is up. We will certainly take a look at the record again. Thank you very much. Next matter is International Franchise Association versus the City of New York. Whenever you're ready.
Good morning, Your Honors, and may it please the court. My name is Ailey Friedberg, and I'm an attorney at Littler Mendelson, PC, and we represent the appellants. We're here today to explain why the New York City Fair Workweek law is preempted by the New York State labor law under the doctrines of both conflict preemption and field preemption. Justice Engoron, in his issuing his decision in the trial court level, noted and characterized the Fair Workweek law as a law that interferes with the freedom of contract, distorts capitalism, and is surprisingly complex, and is arguably unwieldy. Despite his accurate assessment of the Fair Workweek law, Justice Engoron nevertheless rejected our preemption arguments, and in doing so, he somehow failed to cite in his decision to the only 2 decisions that are directly in point and that address the preemptive effect of the New York State labor law. And those decisions are found in the ILC Data versus Suffolk County case and the wholesale laundry case that we cited to in our briefings. And if it pleases the court, I'd like to start with our conflict preemption arguments first. Direct conflict preemption occurs when a city or a locality passes a law that directly conflicts with a state law. And conflict preemption also occurs when a city law prohibits conduct that is expressly and directly permitted in a state law. This is exactly what occurs in the New York City Fair Workweek law on a number of levels that we've described in our briefing papers. And just by way of example, a few of the activities that are permitted under state law but are prohibited in state law, for example, are changing schedules with less than 14 days notice. Under the state law, Your Honors, and the regulations that govern employers, including fast food employers that are governed by Fair Workweek law, there's no prohibition on employers calling in employees to work with less than 14 days notice. Likewise, under state law, there is no prohibition that requires an employer, fast food employer, to obtain the consent of employees before getting called in with less than 14 days notice.
Although-
Likewise,
Why is that a conflict? That sounds like a field preemption argument, not a conflict preemption, the absence of something. So I'm having trouble following exactly what you're arguing now.
well, that there is field preemption as well, Your Honor, and with your permissions.
Something, how can it be a conflict?
Because that is precisely the definition of conflict preemption, where the state law permits an activity, yet the city law, the local law, prohibits the same activity that is permitted under state law. So going through this litany of activities that the state law expressly allows, whereas the city law prohibits or puts obstacles in front of, is the very definition of what conflict preemption is, Your Honor. So again, here.
Let me ask you a question. Now, aren't all of these provisions meant to protect employees rather than employers?
No, that's not right. The provisions in the fair, and that is certainly an argument that both the city and the interveners assert in their briefs, but it's frankly, Your Honor, completely incorrect. What the Fair Workweek law does is prevent obstacles for employers to manage their businesses in a way that allows them to manage their businesses. These laws do ostensibly, and if you read the legislative history behind the laws, the purpose behind the laws is to enforce workplace health, workers' health and safety.
For counsel, that sounds more like, as Justice Kearns points out, protection for the worker, not for the employer.
It is protection for the worker, but in doing so, they put obstacles in the employer's way in managing their staff. So the law, I mean, viewing the law solely through the prism of the employee is frankly a misreading of the law. The Fair Workweek law requires employers to do a whole host of things that are expressly permitted under state law, and that's precisely why direct preemption. Yes, Your Honor.
Is it clear that the intent of both the state and the city laws are to protect workers? So to the extent, what conflict is there between them to the extent of the prism of how workers are or are not protected?
So direct conflict and conflict preemption exist not with what the intent of the law is, but what actions and activities are governed and prescribed and or permitted in both of the laws. And that's the prism in which direct conflict and conflict preemption needs to be gauged.
So counsel, let's focus on the call-in situation. Under the state law, you're arguing that the state law allows employers to do whatever in terms of the call-in, correct?
Correct. And if I can elaborate.
So that the conflict that I perceive would be where the city would say, you're not allowed to call in employees.
That
would be a clear conflict, right?
That's precisely correct, Your Honor.
Right. So I just want to set the baseline here. So what the city did instead was that instead of saying, no, you're not allowed to call in, the city said, you need to give 14-day notice if you're going to change the schedule to the employees. That's what the city said.
That's exactly right, Your Honor.
So
whereas the state said.
So how is that? That's not saying you can't do it. That's just saying now putting another layer, like you call it an obstacle, but at least it's saying, well, the state law left a gap in terms of the call-in situation. Though the locality is saying, well, we'd like to fill in the gap and say you got to give at least 14 days notice to the employee.
Yeah, that's
precisely. I think there's cases out there that say that that's not a conflict.
There are granted, the conflict preemption cases are a bit muddled. There are cases out there, and we believe that the more compelling cases that say that any conflict, any obstacle, as I put it, Your Honor, that prescribes the right of.
Is it an obstacle or is it filling in a gap?
It is an obstacle, Your Honor. And speaking on a practical basis, because I advise fast food employers on this law, the obstacle is an intractable one. What the law in effect does on a day-to-day basis is it precludes the ability of fast food employers, prevents fast food employers from staffing their businesses in a way that they need to meet demand.
Yes. If I may. Could you just tell me where in the legislative history it says that the Fair Work Week law was enacted to protect employers? Because I'm not finding it.
Yeah, well, it's cited to throughout, both throughout the city's papers and
Protect employers.
I'm sorry.
Employers, because you've said repeatedly that this statute was enacted to protect employers.
No, if I said that's, I apologize if that's what I said, Your Honor. I said the statute governs and constrains the abilities, it constrains employers' abilities for managing their businesses. It is not. I don't believe I argued that the law is designed to protect employers. Rather,
Counsel, the law is not designed to protect employees. The fact that these laws, that the city law makes it more difficult for employers, why would that be a basis for finding preemption if additional requirements are added, which admittedly do make it more difficult for employers? Why does that create a preemption situation?
Because that is precisely what preemption is, Your Honor. Where these additional obstacles that don't exist under the state under the state process, under the state regulations, under the state construct in how scheduling works, under the comprehensive state labor law and the regulations that interpret the state labor law, and a city comes in and fills these gaps. It's exactly what they're doing. That is not precisely what's not allowed. It's the gap filling.
Your argument, this is Justice Weber, your argument is that any filling of the gap constitutes an obstacle and constitutes a conflict, wherein I don't believe that there are any cases or anything that says that. Because you are filling in a gap, I don't see how that automatically constitutes a conflict. Unless the locality was coming in and saying you cannot call employees at all. You can never call in an employee to fill in, the work week or whatever. Then I see that as a conflict. But to say that you have to give 14 days notice, I just see that again as filling in the gap, which is something you can respond to on your rebuttal. Respondent?
Good afternoon, Your Honors. May it please the court, Ingrid Gustafson on behalf of the city. I will jump right into conflict preemption since that is where plaintiffs focused today. But as I think, if I took the implication of Your Honor's questions correctly, Your Honor's recognize that this conception of conflict preemption is far too broad. And in fact, the Court of Appeals has specifically said that on multiple occasions, as has this court in the PBA case, in its recent case addressing disability access with the MTA, that is simply because something is permissible as a metaphysical matter under state law does not mean that localities are prohibited from addressing it. And if that were the standard, then this is a direct quote from People v. Cook and Garcia, the Court of Appeals case says, that conception of conflict preemption threatens to render the power of municipalities illusory, because then the city can only act to prohibit conduct that's already prohibited under state law. And what we have here is a situation where there just simply are no state regulations that address the particular scheduling practices that are addressed by the Fair Work Week law, nor are there any provisions.
So this is Judge Owing. I have a question. So why isn't this field preemption then? Why isn't it that the state laws sort of it sets off the intent that this is our area, don't touch it?
There's several reasons, Your Honor, first, and I'm happy to answer any specifics on whichever level we're talking about. When we're talking about the field the city is operating in, we're talking about workplace scheduling. And the only provisions that the plaintiffs have been able to identify in that field are two regulations, isolated regulations, addressing different scheduling practices, call and pay, spread of hours, and nothing beyond that. And two regulations do not field make.
In terms of the field preemption and the state's minimum wage laws and whether or not the scheduling premiums would be preempted by the minimum wage of the state?
Certainly, Your Honor. I think that is one of the two far more discrete fields that plaintiffs identify where courts have found preemption: health and safety, which this law is not, and minimum wage. But this law is also not a minimum wage law. And I don't think plaintiffs even seriously contend that it is a minimum wage law. The law does not change the base level of wages that employees get. In fact, what they're arguing is that scheduling premiums are wages. And they argue that we conceded the point in the reply brief, but I just want to point out that we did not in our respondent's brief. We certainly argued that scheduling premiums are not wages. And of course, if we're talking about wages, that's not a preempted field. It's only minimum wages. But I think this is a very important point, which is the scheduling premiums are not wages. The labor law defines wages as compensation for labor and services rendered, which is not what the scheduling premiums are. The scheduling premiums fundamentally at the outset seek to disincentivize certain employer conduct. And that is the detrimental and sometimes abusive scheduling practices that have arisen in the last several decades, particularly as the result of just-in-time technology. And so when the premiums are working, the idea is actually that there are fewer. That is, the point is not for there to be a lot of scheduling premiums, but rather for there to be a disincentive. And to the extent that
it's a carrot and stick. The whole thing about the minimum, it's actually, I think I read somewhere in one of the briefs, it's more of a penalty. It's sort of like the employers are sort of geared towards not to give people notice. And if you don't give the notice or give the sufficient notice, you have to pay a premium. And I think somewhere in the paper said, you know, the city could have said that you pay it to the city, and the city could have turned around and give a tax credit to the taxpayer. I mean, that's the other way of doing it, right? I mean, so it's not as if this is a set figure that has to be paid every time. This is sort of, if you don't abide by the scheduling issues that we've laid out in this law, in the city law, that's when you, the employer, have to cough up funds for that. Otherwise, if you're complying, you're okay. There's no money out of your pocket, right?
That's correct, Your Honor. It's actually, I would emphasize that it's plaintiffs that referred to them as penalties, not the city. The city will recognize that sometime this is probably going to have.
It's even better if it's a penalty, then it doesn't even affect the minimum wage.
It certainly doesn't affect the minimum wage. And
Counsel, could you frame this within the context of the clopenings?
Certainly, Your Honor. I mean, it's a similar idea with the clopenings provision, that is consecutive closings and openings. I mean, what the purpose of the scheduling premium in that context is the same, which is to try to disincentivize employers from doing that to their employees. And to the extent that they do get employee consent for that type of scheduling, the money compensates the employee for the costs that are being imposed on them by the employer's scheduling practices, which is a very different thing than compensating them for work performed. The scheduling premiums, I would just like to emphasize too, are tied not to how many hours are worked. In fact, you can get them for not working at all, but rather to the amount of notice that you get. And so there simply aren't wages at all. But again, even if they were, that the minimum wage is actually a completely distinct field. And I would like to address very quickly at the end this argument that things are somehow different because we're talking about the labor law. Plaintiffs ultimately have no support for that contention. The labor law doesn't say that. Both Wholesale Laundry and ILC Data Corp addressed far more discrete fields than the labor law generally. I think if they held what plaintiffs said they hold, the analysis would have gone very differently. And the municipal home rule provision that plaintiffs rely on extensively in reply also certainly says nothing about the labor law being broadly preemptive. What it in fact says is that localities aren't authorized to supersede the labor law. But returning back to the beginning point, where the city is acting here is with respect to specific scheduling practices that are not addressed at all by state law and are fundamentally trying to get at different negative practices than those addressed by state law.
Thank you. Any other questions? No, thank you very much.
Thank you.
Yes.
Good afternoon, Your Honors.
Yes, thank you.
This is James Reef from Gladstein, Reef and McGinnis on behalf of the individual respondents. I want to start just by supplementing one point that counsel for the city alluded to, which is the concession by the plaintiffs in their complaint, no less, that the premiums that are required under the Fair Work Week law in the event of the failure to provide adequate notice are penalties. And I want to point out that in 3 consecutive paragraphs in their complaint, paragraphs 18, 19, and 20, the plaintiffs repeatedly made that concession that they're not wages, they're penalties. And now later on, of course, they've decided to turn that upside down and claim that they're wages. But at the time that they brought the case and in their written complaint, they were penalties. I want to turn to the field preemption question, and I want to talk about it at a fairly specific level. The plaintiffs insist that state law, both the state labor law and the regulations, constitute a comprehensive regulation of the area that's addressed in the Fair Work Week law. And they say that over and over in a general way without examining actually what the Fair Work Week law is directed at and what they're complaining about in the Fair Work Week law versus what the state labor law provisions provide that they cite. So there's they articulate 3 facets of the Fair Work Week law that they object to. They object first to the requirement that they provide advance notice of changes in scheduling. They object to what we refer to as the clopening provision, the provision that requires a certain minimum level of length of time between the closing of work on one day and the opening of work by the same employee on the next work day. And thirdly, they complain about the requirement that they offer current employees newly available work before they go out and hire new people to perform that work. So when we look at the provisions of the labor law and the regulations promulgated under that, they have very little, if anything, to do with the provisions that they object to in the Fair Work Week law. So before we even get to the question of whether there's a comprehensive regulatory scheme, there's a question about whether, to what extent the labor law addresses at all what's in the Fair Work Week law. So the provisions in the state law that they specifically invoke are labor law sections 142 through 144, which pertain to provisions that protect the rights of child laborers. Sections 160 to 162, which established the legal workday and insist on at least 24 consecutive hours of rest in a calendar week. And third, provide for meal breaks. And then they rely on the minimum wage provisions in the Minimum Wage Act, which is Labor Law Section 650, et cetera. And they also rely on the call-in pay regulation and the spread of hours pay regulation. And when you compare those to the provisions of the Fair Work Week law, you'll see that none of them has anything to do with providing notice, advanced notice of a change in schedule. None of them has, with one minor exception, has anything to do with addressing the question of rest of an employee for an adequate rest period. And none of them has anything to do with the requirement that they offer work to existing employees before they hire new employees. The only provision of state law that has anything whatsoever to do with what's in the Fair Workweek law might be said to be the law that requires at least 24 hours rest in one 24 hours consecutive rest in a 1 week calendar week, and that relates at least minimally to the clopening provision, which requires a certain amount of rest between the work performed on one day and the work performed on the next day. But that's the sole connection, the sole intersection of the state law and the Fair Workweek law. And that's why we say that there's no basis whatever for this notion that there's field preemption, because there's absolutely no comprehensive regulation in the state law of anything that's addressed in the Fair Workweek law. The one potential overlap, this question of the 24 hours rest and the time that's provided in the clopening provision is insufficient, and courts have repeatedly held that kind of one minor overlap is insufficient to create field preemption. The mere fact that the state law and the local law address the same subject matter is alone insufficient to establish field preemption. The courts have said that over and over and over again. And so in sum, there's just no basis for the field preemption argument whatsoever.
Thank you. Any questions? No? Thank you very much. Ms. Freeberg, you have 2 minutes on rebuttal.
Thank you, Your Honor. And if it pleases the court, I'd like to address the field preemption issue as well, since I didn't really get to it in my opening. I'd note that in the intervener counsel's presentation, despite his so-called case after case after case that he was referring to, he didn't refer to wholesale laundry or ILC data once. And those are the only two cases that discuss the field preemptive effect of the New York State labor law. And both of those cases happen to hold that the New York State labor law does have field preemption and prohibits cities and localities from passing laws that address topics covered under the state labor law.
Well, wholesale laundry, excuse me, deals with minimum wage.
Wholesale laundry addresses a minimum wage statute that the city passed.
That the state has preempted the field of minimum wage. That's what wholesale laundry
and wholesale laundry held that the minimum wage law, which encompasses all of the provisions that Mr. Reif just discussed, including the scheduling provisions, does have that preclusive effect. And wholesale laundry also addressed Section 655 or the Section 650 et sec of the labor law, which vests with the Commissioner of Labor the power not only to set minimum wage rates throughout the state, but also to establish regulations to carry out the purposes of the article, and to say, which includes, and this is in the statute itself, and this is the minimum wage law that has field preemptive effect, call-in pay rates, split shifts, excessive spread of hours, breaks, and other rules covering substantially the same ground. This is exactly why wholesale laundry preempts the city Fair Workweek law, because it is these scheduling issues that the state statute, the state labor law, Section 650, has solely given the power to the Commissioner of Labor to establish rules governing exactly these issues. And case in point to show that this is among the rules that the Commissioner of Labor has exclusive jurisdiction to look over are the predictive scheduling regulations that the Commissioner of Labor promulgated and opened up for a notice and comment period not even 2.5 years ago. They provided rules that mirror exactly what the New York City Fair Workweek says. They took 2 bites at the apple to promulgate those rules, but they decided in its wisdom and in its discretion that it wasn't appropriate. So what the fact that the Commissioner of Labor can promulgate these rules under the same section that wholesale laundry says has field preemptive effect shows that this mechanism, that the state statute has established a comprehensive mechanism for controlling this entire area of law, which isn't solely limited to minimum wages, but is rather far more expansive than that and governs not just wages, but also premium payments, penalty payments, and employee scheduling. And that's the very text of the law. And not only that, but the law is, the labor law is just so expansive. What the respondents are urging this court to do is take a microscopically narrow view of what the labor law does and what predictive scheduling does. And they're asking the court to say, oh no, only predictive scheduling applies. And by the way, they've conceded that the New York State law does have provisions within it, including the day of rest and child labor laws and the call and pay premiums, which are in essence predictive scheduling rules. They are, in essence, despite all the protestations to the contrary from the city and the interveners, these are predictive scheduling rules. And the state has decided to address the predictive scheduling rules by implementing the call and pay premiums, by prohibiting work 7 days a week and requiring.
Thank you. Your time is up.
Thank you
very much. Salomon versus EIP Global Fund.
Good afternoon, Your Honors. Leonard Lesser for the plaintiff appellant, Kenneth Salomon. I thank you very much for your time. I hope you and your families are safe and healthy. I'll be as brief as possible. We're here on an appeal of a decision by Justice Sherwood on a motion to dismiss, a pre-answer motion to dismiss under 3211A1 and 3211A7.
Judge
Yes.
Kerman, why should we address the estoppel argument when it was an argument that wasn't raised to the court below?
Okay, well, all of the facts concerning the estoppel argument with respect to the usury defense were set forth not only in the pleadings, but in Mr. Salomon's affidavit. Any argument based upon those facts would have had to been addressed, and the law is very clear that this court, doing a de novo review of this type of argument, can address the estoppel argument because all of the facts are in the record. Nothing new has been asserted. It's all there set forth in Mr. Salomon's affidavit and his pleadings regarding the special relationship that he had with the defendants, the circumstances that led to the forbearance agreement, the defendant's assurances that they owed him the money, that the forbearance fee was not going to be considered interest, but rather an effort to try to compensate him for the value of the Apple stock that he liquidated to make the loan. All of those facts are properly in the record, and this court, pursuant to its precedent, clear precedent, as we set forth in our reply brief, give this court the ability on its de novo review of the motion to dismiss decision to consider those facts at the motion to dismiss stage, which again, we're dealing with a motion to dismiss, pre-answer. They haven't even pleaded the usury defense. They just raised it as part of an argument on a motion to dismiss. And the facts set forth in Mr. Salomon's affidavit clearly set forth numerous factual issues regarding the applicability of usury in connection with the forbearance agreement.
The only real argument why usury would not apply, though, is that the forbearance fee is not interest. Isn't that correct? I mean, if
Correct.
the forbearance fee is interest, then it would be usury as a matter of law.
Well, wait a second. If the forbearance fee is not interest, then it's not part of.
I'm sorry. If the forbearance fee is interest, then it would be usurious.
Well, if the forbearance fee, if the forbearance fee could legitimately be asserted as a component of interest, then the defendants arguably have a usury defense. Whether or not the usury defense ultimately succeeds, however, is going to be based upon the facts and the record. It's the defendant's burden, because it's their defense, to prove their usury defense through clear evidence as to all of the elements of usury, because none of it is presumed. And
Okay,
that's the.
so let me ask another question. Why is a forbearance fee not interest, where you're basically arguing it's the cost of not being able to use the money? Isn't that the classic example of what interest is?
Well, not in the context of this case, because there was very discrete discussions about how this money came to be given to the defendants. Mr. Salomon makes very clear that these were friends, business colleagues, and associates that came to him for an emergency. They claimed it was an emergency. They knew that he liquidated his Apple stock in order to give them a very short-term $2 million loan that was supposed to be paid back immediately and no less than 30 days. They didn't repay it. They admitted that they owed him the money. They admitted that they had to step up and not only pay him what was owed under the demand note, but to compensate him for his lost opportunity cost in the Apple stock. And that was not interest. That was a separate negotiated fee.
And different than any other lender who, while they don't have the money, lose the ability to make money on their money. And that's why they get paid interest, because they've given up their own ability to make money. I mean, you're being much more granular here about how the money would have been made, but why is it distinguishable on a theoretical level from any other lender who gives up their right to make money one way or another while they're lending the money?
And to follow up on my colleague's question, your client also stated that it was to compensate him for losses he sustained by providing the loan to the defendant, i.e. the cost of the funds. That would seem to me to be interest.
Under the circumstances that we have right now, yes, it may seem to be interest, but the specific facts that have been pleaded at this stage, pre-answer motion to dismiss stage, is that the funds that were utilized to provide the $2 million to the defendants came out of the Apple stock that Mr. Salomon liquidated that was supposed to be repaid back very quickly. And after it wasn't repaid, the parties had multiple discussions about that and what was going to happen and how Mr. Salomon was to be compensated. And what they discussed repeatedly, and this is in the affidavit, was that this discrete amount of money was to compensate him for a discrete period of time that he lost the ability to buy back his Apple stock and participate in the run on the Apple stock for that period of time. But even if we get to the point,
counsel, your argument is that because there was a business relationship and a friendship between the parties, that estoppel applies, and therefore this is not interest, right?
100%. So it's a two-part argument, because this is a defense to our forbearance agreement claim. They're asserting a defense pre-answer. In response to the pre-answer motion to dismiss, we say there are facts at issue that call into question whether or not it is even interest to be included in a usury allegation. And two, even if you can argue or allege as a defense that this is usury, you are stopped from supporting that usury defense because not only of the special relationship between the parties, but because of the negotiations based upon that special relationship, the assurances that were made to the plaintiff, the representations that were made to the plaintiff regarding the circumstances of not being paid back, why he needed to be compensated discreetly for those funds. All of that under the guise of a motion to dismiss, a 3211A1 and a 3211A7 cannot be decided right now. The only thing that gets decided right now.
I believe you have time on rebuttal. Yes, you do.
Yeah, I want to address the fraud claim on rebuttal. I'll do that. That's fine.
Thank you so much.
Yeah.
Good afternoon, Your Honors. Let me get right to the estoppel in payas argument. I hope I'm pronouncing that right. It's the first time I've come across that defense. It is not properly preserved for an appeal. It was not argued before Justice Sherwood below. It is not unavoidable from the record, which is a requirement in order for the appellate court, Your Honors, to review it as I read the law. It's not a purely legal argument, as Mr. Lesser eloquently laid out, a myriad of facts that would need to be delved into in order to address that argument.
Counsel, why can't we address it, though, on the ground that all the facts needed to address it are before us, or the allegations are before us, and this is a pre-answer motion to dismiss the complaint?
And the court may, of course, and then I would say there's an allegation that's necessary that's missing, which is that the defendants induced any reliance in the legality of the transaction. That's an absolute requirement for estoppel in payas. There's no allegation, no even allegation of that. So if the record's closed, that's fine. We win on that point. I would respectfully submit. It's also worth noting that Mr. Salamone was counseled at the time. He had a law firm representing him. It wasn't.
Not only though that they, I mean, on a motion to dismiss, it's not only that they that they stated all the allegations. It's does a cause of action exist? And for purposes of the record now, isn't there allegations which would be sufficient to state a claim for estoppel for purposes of at least a pleading motion to dismiss?
No, there is not, Your Honor. There's had to be an allegation that one of the Chityalas told Mr. Salamone that the interest was legal, that it was not usurious, that he relied upon that statement in believing it was legal, did not consult with his own attorneys, apparently. And that even allegation is not in there. It's not in the appellate papers. It's not in the supplemental affidavit. It's not in, obviously not in the motion arguments before the trial court, because this argument wasn't raised there. But even if it were properly preserved, that allegation is just not there. And it wouldn't make any sense because Mr. Salamone is a highly sophisticated individual himself, had highly sophisticated counsel, and the Chityalas, one of the younger Chityala is not an attorney, neither is alleged to be an attorney. And there's nothing about their special relationship, as it's sort of vaguely hinted at, is supposed to be fiduciary-like. There's nothing about that that says either Mr. Chityala has some superior base of knowledge about this usury to Mr. Salamone, a former managing director at Morgan Stanley.
Related to the issue of whether or not the forbearance fee would constitute interest in discussion, because it's only usurious if the forbearance fee constitutes interest. And didn't the parties have discussions about what this forbearance fee would or would not be and what its purpose was that could have induced reliance?
Yeah, maybe. I mean, Mr. Chityala called it special interest at one point. That's in the record. That's in Mr. Salamone's brief at page 18. The complaint recognizes that the forbearance fee is really interest. That's at the record at page 25. And the court, and certainly the trial court, felt obligated to consider a forbearance fee as usurious, as if it were interest, because the case law, and that's the Lancaster case, states that a fee in order to forbear is treated as if it were interest for a usury calculation, period. So, I mean, it has to be considered interest.
I guess my question was one, though, that even if legally it must be considered interest, couldn't the plaintiff in this case have relied on the discussions about how these parties would treat it?
No, there is no representation, no allegation of a representation that it was legal, that it was proper to consider the forbearance fee as something other than interest.
And what about the special, counsel, what about the special relationship?
Well, it's vaguely hinted at, but as far as the specifics, there's a relationship that the elder Mr. Chityala and Mr. Salamone are shareholders in a company. And other than that, there's nothing that's said. And shareholders in a company don't have a fiduciary relationship, so far as I know.
And also, but isn't there also an allegation that the father went in person to the plaintiff's office and said, basically, I have an emergency, I need a loan, I need it now?
Yes.
Isn't that indicia of a special relationship that could be fleshed out later on at deposition, for example?
It could, yes, Your Honor, but that is different from saying that there is a relationship that is pled that would suggest Mr. Salamone, an extremely sophisticated executive, relied on the legality of the forbearance fee. Not, I gave him the loan because I've known him for a long time. And that issue's disposed of, really. I mean, the loan's been paid back. But he's got to rely that it was the legality of the transaction. Or to say, you know, Sridhar, I've known you for 20 years. We're partners in a company. I don't need to call my lawyer. You tell me it's okay. You tell me this isn't usury, because I remember somewhere from business school that it was. Fine, we'll make it that. That's not this case. It was called interest repeatedly by the Chityalas, and that's in the record. So how it was recast, that was recast by Mr. Salomon. But in any event, I mean, there's just no allegation that it was legal. So it's stated in the record that the Chityalas expressly acknowledged and understood that the forbearance fee was not interest. Not that they said or they suggested anything to the effect that it was not interest, nor that Mr. Salomon relied on that statement. As far as the fraud, I think Mr. Lesser is going to get to that. I can hit that quickly. The fraudulent statements and the bank records and so forth that are probably going to get discussed all made after the loan was done, October 10th, 2019. Can't rely on those. It's as if a tenant gets a lease, gets into an apartment, 2 months later says, the check's in the mail, I'm going to pay you, and then didn't. That's not fraud. That's a breach of contract. I would finally note that as far as the damages, if the damages for the fraud are to be considered any different from the demand note itself, the plaintiff himself has vitiated that argument because at the record, page 38, it is stated the lender has incurred damages as of November 27, 2019, including but not limited to, states a lost economic opportunity, 0. And so
Thank you, counsel.
Yes. And
thank you. Your time is up. Thank you very much.
Thank you, Your Honor.
Thank
Mr.
you.
Lester, you have 2 minutes.
Thank you, Judge Weber. Very briefly, what you heard from Mr. Mullaney in terms of how he's characterizing what has been pleaded is absolutely wrong. I'll point you to page 103 of the record, paragraph 32 of Mr. Salomon's affidavit, which is further particulars for purposes of the complaint. Mr. Salomon expressly alleges, quote, Sridhar and Shreya specifically and vigorously negotiated the amount of the forbearance fee and expressly acknowledged and understood that this forbearance fee was in no way to be treated as an additional interest charge or disguised interest. And the further documentary proof supported in Mr. Salomon's affidavit with all the text messages show that. It shows that these individuals were beseeching Mr. Salomon for forbearance, for paying him additional consideration for his losses, and that this forbearance fee was not to be considered as interest. But again, even if it is supposed to be considered as part of interest for a usury defense, the special relationship and the other elements of estoppel give rise to numerous issues of fact that need to be flushed out before that usury defense could be resolved in the defendant's favor on a motion. This isn't even a motion for summary judgment. And the special relationship is not, as Mr. Mullaney says, just that they did business together. It's that they were personal friends, had been in business together for several years, and the loan itself was based upon representations of gratitude expressed for their friendship and their trust. And so that special relationship and those facts are all there for the estoppel defense to the usury defense. On fraud, also completely wrong. Judge Sherwood was wrong. The fraud claim was not based upon an alleged non-intention to perform. It was based on allegations of false statements of present fact, namely that there was 500 million euros coming in.
Counsel, Judge Kern, even if you're right about that, why is that duplicative?
It's not duplicative. First of all,
duplicative.
The fraud claim is not duplicative for several reasons. One, it seeks different additional damages because the forbearance agreement covered the losses through December of 2019. The fraud claim covers more than that. And even if it could be argued to be duplicative, this is a motion to dismiss. CPLR 3014 makes it very clear that claims can not only be pleaded alternatively, but hypothetically. And this court, about 2 months ago in the case Sheer Entertainment versus Cohen, 189 AD 3D 423, First Department 2020. This is the quote from that case, quote, defendants argue that in any event, because the damages are the same under either theory, the fraud claim must give way to the contract claim. We disagree. We hold that given the earlier procedural stage of this action, plaintiffs should be permitted to plead the cause of action for fraud in the alternative. The fraud claim is based upon misrepresentations of present fact the allegation and the statements and the misrepresentations that they had 500 million euro coming in through this Nicholas James entity. They sent documentation, which we allege to be fraudulent, itemizing this money that they allegedly had that was used to induce this money. And that is the essence of the fraud, not an intention not to perform. That's why the fraud claim is properly pleaded, even at this stage, even if it's in the alternative, Your Honor.
Thank you so much, Counselor. Thank you very much. Thank you both.
Thank you.
Next matter is Garandola versus Shea.
Good afternoon, Your Honors. May it please the court, my name is Peter Tillum from the law firm Tillum & Associates, and I am here on behalf of Mr. Garandola, who is the owner of Garandola and Shutkind Construction. He's also the president, and he has been a licensed gun owner in the state of New York since 1996, almost 25 years. In 2015, the New York City Police Department gave him what's known as a special carry license, which is a license that essentially validates a license given by a county court judge outside of New York City, or another licensing officer outside of New York City.
Yeah, so Counsel, we are familiar with the facts. So the issue is, how is this arbitrary and capricious?
Well, Your Honor, I think that's the nutshell of the issue here. And in the question, I think, is a narrow one here. And the issue is whether or not there is a statewide standard for what constitutes proper cause, and whether or not there's really any strict standard of what proper cause is. The fact is that the NYPD argued, even in this case, that they can make two different decisions, that one officer that reviews it can say yes, and one officer who reviews it can say no. And that is the definition of arbitrary and capricious. In 2015, they granted Mr. Garandola a license. A county court judge in Putnam County granted Mr. Garandola a license. And now the NYPD arbitrarily is refusing to consider.
Counsel, I don't understand your argument with respect to the granting of a license in Putnam and the granting of a license in New York City. What details, what documentation did your client provide that showed that he was the subject of special threats, or of threats rather, or special circumstances that differentiated him from the people in the surrounding community or in that area of business? My understanding is that not very much was offered.
Well, I don't believe that's the case, Your Honor, but I know that the NYPD is arguing that. But in fact, he put in the same facts essentially that got him the license in 2015.
Essentially is the essentially how he wasn't picking up rents from tenants, and he wasn't paying fast food employees after hours. That those facts were different.
Well, in fact, nothing has changed for the appellant in this case. What happened is the NYPD, he did this without a lawyer, and this is a fairly.
We can only go on what was presented to the NYPD, right?
Understood. But really, the nutshell of his argument in 2015 and remains is that he is the president of this company, that he has to respond in the middle of the night to buildings under construction in all kinds of areas in New York with valuable equipment. And,
so, Counselor, in the 2015 application, he stated that he had paid per diem food processing employees at the end of their shifts during off hours and collected rents from tenants. In the 2018, he did not mention any payments to employees during off hours, and he did not mention any rent collections. And I'm not really clear. I read somewhere something about a high crime area. I don't know whether that was mentioned in 2015 or mentioned in 2018. So in 2018, we have no mention of payments to employees during off hours, and we have no mention of rent collections. We have mention of the fact that he, I guess, was the owner of a construction company, and that he had sites or visited sites here in New York City.
Correct. Justice Weber, you're completely correct that essentially the thrust of his letter, both in 2015 and 2018, and he neglected to include the issue of rents in the 2018 letter, and he neglected to include the issue of paying these employees. But essentially, he went into great detail about the fact that he is the owner of this construction company and often has to respond to dangerous neighborhoods with expensive equipment and tools late at night or the early morning hours.
What expensive equipment and tools?
He was not asked to detail it, and in fact,
so counsel, so far you've indicated 3 differerences that could be dispositive, right?
Well, I don't believe there's any difference with the issue of tools. I think they didn't ask for any more detail in 2015, and they didn't ask for any more detail in 2018. The NYPD is arguing essentially that that 2 different officers who review this can come up with different opinions. And
I know, counsel, you said that before, and I'm not really clear what you mean by that. What do you mean that 2 different officers? Because are you talking about one individual in Putnam and one individual in New York?
No,
or are you talking about? Go ahead. I'm sorry.
I'm sorry, Your Honor. I didn't mean to interrupt you. What I'm saying is that they make an argument that that essentially 2 different reviewing officers from the NYPD can look at this and come up with 2 different opinions. But
is that because the application was initially approved in 2015 and not approved in 2018? Is that what you're referring to?
Correct.
Oh, okay.
Okay.
Are you trying to argue that there's some sort of collateral estoppel going on here?
I don't know.
Because that sounds like what you're saying, and
Yeah,
you know
I don't know
that can't be accurate.
Justice Owing, I'm not saying that it's collateral estoppel, but we did argue in our brief the non-acquiescence doctrine that essentially if the agency is going to change their opinion, they have some obligation to explain it and not just say, hey, 2 different reviewing officers can come up with different opinions. But we do think, and this was an important point in Kachowski. Kachowski was a challenge to the proper cause scheme in New York. And the argument was in federal court that this whole situation is unconstitutional, that proper cause is not constitutional. And in upholding Kachowski, the Second Circuit, in upholding the proper cause scheme, Kachowski, the Second Circuit made very clear that there is one statewide standard. In fact, the NYPD, while they criticized my client for referring to it as an endorsement, and this is in the record at page 243, on the application, there's a box, and my client checked the box special, and it says out of city validation. There was a county court judge that reviewed my client's background. There was a county court judge that made a determination that he had proper cause. And now the city made a determination.
Counsel, isn't proper cause different in Putnam County than it is in New York City?
Your Honor,
doesn't the penal law say that proper cause has to be established, and doesn't the penal law make a distinction between New York state carry licenses throughout the state, but for New York City?
Justice Gonzalez, the answer is no. And
really,
in the Second Circuit,
so penal law section 406 doesn't say that special permits must be issued by New York City police commissioners, that statewide licenses, carry licenses don't apply.
It absolutely does say that if you have an out-of-state license, you need permission from the police commissioner.
No, not out-of-state, out-of-county.
I'm sorry, out-of-county. I misspoke. If you have an out-of-county license, then you must have permission from the police commissioner. But it doesn't say that there's a different standard. In fact, just the opposite. The case law.
Well, why bother having the police commissioner make an independent review of the application?
Well, the police commissioner would have to make a determination that there's proper cause in New York City, that essentially that there is some
precisely, which goes to my question. There's a determination by a Putnam County judge pertinent to conditions, circumstances outside of New York City. there's another review that takes place pertinent to conditions within New York City. So you are mixing apples and oranges, don't you think?
I do not believe I am, Your Honor. What I'm saying is that Mr. Girandola was granted that license because of his construction business. And in fact, we know that his business operates in New York City. So if in fact his business operates in New York City, why can the police commissioner disregard a finding of a county court judge who already made a determination? And I'm not arguing that it's an automatic thing, but what I'm arguing under these facts, where you have the police commissioner who already granted the license.
You're basically arguing collateral estoppel. I agree with my colleague, Judge Owen. You are arguing collateral estoppel.
Justice Gonzalez, it's not really collateral estoppel. What it is it's not acquiescence.
It's not really collateral estoppel. It's kind of like collateral estoppel.
It
But
looks
hear
like
from your, it looks like it, but it's really an apple, not an orange. We'll hear from your adversary. Maybe, maybe not.
Yes, Clay Henry on behalf of the respondents. So petitioner in this case, Your Honor, hasn't even.
So I have a question. Obviously, is he precluded from filing another application?
Absolutely not.
So he could file another application and perhaps include the information that was initially stated that was missing. Is that correct?
Correct, Your Honor. You know, and I just want to say in this case, petitioner hasn't come close to establishing proper cause for a special carry license. The only information in his application that was even marginally relevant to showing proper cause is that he worked in desolate areas and carried high value tools. But the city's local regulations established that even working in high crime areas isn't sufficient to establish proper cause, and that's necessary.
You also mentioned the waterfront, which I don't even know what that is in New York City. I was trying to figure out what's the waterfront. I mean, it's like, you know, I didn't know. On the waterfront is all I could think about. But to the argument in terms of the estoppel, he was issued the carry permit in 2015, and now we come to 2018, and wherein he didn't mention, you know, the collections and the off hours, because he was granted the permit in 2015. Aren't we kind of like in 2018? You know, why would it now be that he should not be issued the permit where the applications are similar?
Well, because in 2015, he included those statements about collecting rents and paying per diem employees that at least arguably supported the conclusion that he handled large amounts of cash on a daily basis. And that arguably supported the conclusion that he had proper cause. He didn't include those statements here. He didn't even, and so as a result, he doesn't even really come close to satisfying the city's regulations, which require you to show that your job places you in extraordinary personal danger. And you have to document that either with police reports or other proofs of threats, or you have to show proof that you carry frequent cash on a regular basis. And then you have to document and substantiate those statements. And he hasn't done that here. He had two opportunities before the license division. In fact, when he submitted his first letter of necessity, the license division responded to him and told him, hey, you know, you haven't satisfied your burden. Please submit documents showing threats to your life or other instances where you've been placed in danger, or please submit bank records or documentation showing frequent cash deposits. He submitted a second letter of necessity, again, talking about desolate areas and carrying high value tools. But the NYPD doesn't give a license to everyone who walks around the city with high value tools. The same way people who walk around with expensive laptops in their backpacks don't get to carry a loaded handgun. And so ultimately, the application in this case was materially different from his application in 2015. And on that basis alone, it was rational to deny his renewal application. Yes, Judge.
What about your adversary's argument that a Putnam County judge reviewed his application for a carry license and allowed him to do so? Why not New York City?
Well, because the penal law states very clearly that licenses granted outside of the county, outside of the city, are not effective here unless you have a special permit granting validity by the NYPD commissioner. And it's not just in that section, but throughout the penal law, the legislature evinces its intent to treat New York City differently than the rest of the state when it comes to issuing concealed carry licenses. And to the extent that he has a complaint about that, his complaint is with the legislature, not with the license division. He seems to think that he's entitled to a carry license here simply by virtue of having one in Putnam County. But that's just not the case. And the standard is certainly going to be applied slightly different in different locations based on context and locality and what each county requires. But that's contemplated by the statute. The statute gives each county the authority to administer and regulate the licensing scheme. And in New York City, that requires applicants for a carry license to establish proof of extraordinary personal danger and submit that to the NYPD commissioner, who grants a special permit or who grants validity to any permit you've received out of county. And he simply failed to establish, it's his burden. He failed to meet that burden. He had 2 opportunities to do so. And he didn't make that showing.
Thank you, Counselor.
Thank you.
You have 2 minutes on rebuttal. Muted.
Thank you, Your Honor. The police department asked for things that they knew Mr. Girandola didn't have. He didn't claim he had cash deposits. He didn't claim that he was the victim. In fact, in his letter of necessity, he specifically indicated that he was not the victim of a crime. And in fact, if you look at the rules and regulations of the NYPD, it specifically says that being the victim of a crime is not enough. He went into great detail in his letter of necessity, which is at page 40 in the record, about arriving alone. He has to wait sometimes there until other people arrive, that he's by himself. He has to go out and inspect. He went into great detail about the situations he found himself in. With regard to...
But Counsel, because you're in a desolate area by yourself, does that mean that you'd be eligible for a carry permit?
I think that if your job calls you to desolate areas to go into abandoned buildings or buildings that are under construction in the middle of the night at 3 o'clock in the morning, you may be in a situation where you're subject to greater danger than the average person in the community. Yes, I think that someone who has a job where they're carrying valuable items into a dangerous area at 3 o'clock in the morning, yes, it may be appropriate for them to have a license to carry a gun. I would also point out that the term proper cause has to mean something. It can't just mean that, if the police department feels like giving it at this time and not that time, that's okay. According to the Second Circuit, the entire legal regime in New York that allows for licensing is dependent on there being one statewide standard for what proper cause means. And I think it's very important that this court articulate what proper cause means. It cannot be something arbitrary.
Counsel, I have to tell you, I just took a quick peek at the documentation provided by your client. It lacks a lot of specificity. It's couched in generalizations, and doesn't your client have the opportunity to start over and file an application?
I'm sorry to interrupt. He did, Your Honor, and it's outside the record, but he was denied. And each time is quite an expensive and quite a lengthy process. So that's why he appealed this one, because he sensed that he would get denied if he didn't appeal it and win on appeal.
Thank you very much, Counselor.
Thank you, Your Honors.
Have a good day.
Time today.
Take care.
You too.
Alameda versus Concourse Rehab.
Yes, Your Honor. May it please the court, Shannon Henderson, Kaufman, Borges, and Ryan on behalf of defendant appellant Concourse Rehabilitation and Nursing. Your Honors, the plaintiffs here failed to raise a triable issue of fact as to their medical malpractice and public health law claims because they relied on an unqualified expert. In support of its motion for summary judgment, Concourse submitted the expert affidavit of Dr. Lisa Honkanen, who is a geriatrics expert who established that she had experience treating geriatric patients in nursing homes, and she opined that Concourse treated the decedent in full conformity with the standard of care. Concourse also submitted the expert affidavit of Dr. Azar, a forensic clinical pathologist with experience in autopsy. He testified that the autopsy showed that the decedent did not die as a result of a fatally high or low blood glucose level, but instead died of atherosclerotic and hypertensive cardiovascular disease, which is what the medical examiner also found. In opposition, plaintiffs provided the purported expert affidavit of Dr. Barry Root, a physiatrist who is a specialist.
I can't tell whether the static is coming from you or whether someone has an open mic, but we're getting a lot of static when you speak. At least I'm hearing static.
How is this? Can you hear me? Is it still staticky?
No, that's good.
Okay, should I start over or keep going?
No, we could hear you. As you said, every now and then it was some static coming in.
Okay. Dr. Root is a physiatrist. He is certified in physical medicine and rehabilitation. He is opining outside of his area of specialization here, and at no point in his purported expert affidavit did he establish his qualifications to opine outside of his specialization, or why his opinions as to the treatment of a geriatric nursing home resident is reliable, or how he's qualified to testify about pathology findings, autopsy findings.
So if I may, so here the question is whether the rehabilitation facility followed the directives of Bronx Lebanon pursuant to the transfer of the patient from one facility to the other, right?
Well, the facility, Concourse, did, the attending physician at Concourse did enact discharge instructions of Bronx Lebanon. And the issue is whether the care provided to the decedent as far as the care of his diabetes met the standard.
So the directives indicated that the patient was to receive shots of insulin 4 times a day, 3 with meals and 1 at bedtime. And the record apparently is devoid of any entries indicating that that insulin was administered pursuant to the directive. So why do you need an expert as opposed to even just a regular old doctor to read medical records and say, or rehab records and say, it's not here? There is no indication that the insulin was administered to this patient at any point in time.
Well, respectfully, the medical record does show that the insulin was administered. The dispute is a result of the decedent's partner, who testified that when she was there at the nursing home with him, she did not see the insulin administered. Our argument is that Dr. Root, the physiatrist, is not qualified to testify about the standard of care as to diabetic care. And even if there is a dispute of fact over whether the insulin was administered or not, there's no causation here because Dr. Azar, our pathologist, testified that the decedent did not die as a result of a fatally high or low blood glucose level. Dr. Root, in opposition, is not qualified and does not lay down the foundation for how he is qualified to testify about pathology reports. He is a physical medicine and rehabilitation specialist, and the law of the state and the decisions coming out of this department are quite clear that when a doctor testifies outside of the scope or opines outside of the scope of his specialization, he has to lay that foundation.
So the cause of death, according to your expert, the autopsy report was hypertensive cardiovascular disease. Is that correct?
Yes.
But also insulin-dependent diabetes was a contributing cause. Is that correct?
That's correct. And Dr. Azar explained that that would be listed because insulin-dependent diabetes would contribute to the development of the cardiovascular.
So whether he received insulin or did not receive insulin would not have been a contributing factor to the cause of death?
Correct, Your Honor. We, of course, our position is that he did receive the insulin according to the medical records, but according to Dr. Azar, a fatally high or fatally low blood glucose level, which of course would be affected by the administration of insulin, did not cause his death. That was not the cause of death.
And the reason I'm asking that is because I thought that there was no indication that he had received insulin that evening before he died.
The medical records do show that he had not received his bedtime insulin. He passed away around 8:30 p.m., so he had not received his bedtime insulin yet. The crux of the dispute here is whether or not his blood glucose was accurately monitored. And Dr. Honkanen explained that blood glucose monitoring is up to the medical judgment of the attending physician, and that in this case, his blood glucose level was appropriately monitored. Dr. Root, who again is not qualified to dispute that recommendation or that opinion.
Counsel, why is an ordinary medical doctor, forget about whether he's an expert in anything, not able to opine about whether or not blood glucose has to be monitored in a diabetic patient?
First, I would just argue that.
Counsel, let me just add on to that question, because it seems to me like you're making two separate arguments. One of the arguments has to do with administration of glucose, and the other argument, though, has to do with what was the cause of death. So your separate argument is that even if, regardless of whether glucose was or was not administered, which you're saying it was, that this expert is not competent to opine on what actually caused the death of this patient, that your expert came out with an opinion that it wasn't lack of glucose that was caused the death, and that expert couldn't respond to that because that wasn't that expert's area of expertise. Is that what you're arguing?
Correct. Dr. Root doesn't lay the foundation for how he can opine as to autopsy findings or postmortem laboratory values. Our doctor, Dr. Azar, testified specifically about the vitreous humor measurement, which is the measurement of the glucose level in liquid in the eye. Because blood glucose cannot be tested postmortem, so they have to test the eye liquid.
Counsel, this is Judge Owing then isn't it then a weight issue and not an admissibility issue? Because to me, it's two separate things. One is, does Dr. Root qualify as an expert? And my understanding of the case law is that threshold is very low. As long as the expert can profess some knowledge of the area he talks about. I mean, clearly, you can't have a podiatrist give you an opinion with respect to a heart issue. But this is sort of like in a gray area that Dr. Root's talking about. So that my understanding is that our department, at least this department, the threshold is very low as to whether or not you should look at the affirmation or not. But putting that aside, aren't we having a disagreement with respect to the opinion that he's giving? And isn't that a weight issue that should go to the trier of fact and not for us to decide?
I would argue that the weight issue, that his opinions, even if they were considered, are vague and conclusory. But just getting back to Your Honor mentioned the low threshold for establishing reliability of an expert opinion. It is not a high threshold, and was not met here. The doctor and the plaintiff did not even try to establish that he was qualified to opine as to autopsy. There's cases out of this court, many cases that I cited in my brief, in which doctors with many, many years of experience, I would mention Bartolacci versus Sassoon, 149 AD 3rd 567, this was a 2017 case, and Justice Weber was actually on the panel in that case. In that case, the purported expert was a general surgeon with 40 years of experience testifying about gastroenterological surgery, and he was trying to opine about the standard of care of a gastroenterologist, and this court held that he could not. Even a surgeon with 40 years of experience could not testify about the standard of care for a gastroenterologist.
But I go back to what my colleague is saying, Judge Owing. So you have a problem, or your client has a problem with the opinion of Dr. Root. He says, irrespective of whether there was a directive as to the insulin, there was no directive as to the glucose testing, but glucose testing is normally done, and it wasn't done here. And when it finally was, just before the patient died, it was 3 times the normal rate. And what you're saying is glucose testing didn't have to be done. There was no directive. And as you just said, and my expert says, you don't have to do it. So doesn't that go to weight? Isn't this information with respect to glucose testing and the administration of insulin something within the ken of pretty much any doctor who could be considered an expert because they are doctors? Here you have someone who's, yes, his field is PM&R, but he also has experience teaching in PM&R. He's an active doctor. He's in the active practice of medicine. don't those things count?
Your Honor, I would just again state that the case law of this court has been very clear that physicians don't have carte blanche to testify about any area of medicine. He could have explained in his affidavit, how he is qualified, but they simply didn't do that here. And as to his opinions, even if they were considered, they're vague and conclusory, and he never even states what the standard of care is for blood glucose monitoring. He states that the current, at the time of the writing of his expert report, American Diabetes Association recommendation.
Counsel, he says, and I've superimposed the doc over the screen. Dr. Root opined, if the facility, meaning the rehabilitation facility, administers insulin, they must monitor glucose levels. Failure to do so is a frank deviation from the standard of the case.
Yes, Your Honor, he says that it must be monitored. He doesn't specify that it has to be finger stick monitoring, and he doesn't respond to Dr. Honkinen's opinion that monitoring the signs and symptoms of hyperglycemia was effective and was sufficient monitoring in this case.
Thank you, Counsel. I'm sorry, you had a minute of rebuttal. You've gone over your time. I'm sorry. Yes, respondent.
Good afternoon, and may it please the court. This is Evan Bain from Ressler & Ressler. We are the sponsoring attorneys of the law firm of Villari, Lentz, and Lynham. At this time, I respectfully request that attorney Leonard Villari be permitted to participate in this appeal.
Participate meaning, is he going to argue the appeal?
Yes, Your Honor.
Thank you.
Thank
yes,
you
may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. Leonard Villari, Lentz, and Lynham on behalf of the appellee. Before we get too far into, I think, some of the questions that you focused on, I don't want to get too far down the rabbit hole, but I want to explain to you why all of this is for naught to begin with. There is a distinct difference between the standard of care for nursing homes and the standard of care for rehabilitation facilities. Concourse is a dual facility center which has both a rehabilitation wing and a nursing home center wing. I know counsel would like to pigeonhole this case into a nursing home case because she has a geriatrician who is a family doctor for elderly people.
Oh, counsel, I don't want to cut you off. This is Judge John. Are you trying to say that their experts didn't tell us about what happens in the rehab? They got these doctors coming in, but they didn't tell us doctors in terms of the rehabilitation side of your client, of their client. Is that where you're headed?
Well, yes, sir, I am. Where I'm headed is essentially this. Mr. Almeida was 73 years old. He had suffered some abdominal problems. While in the hospital, he suffered an ST-elevated myocardial infarction. It requiring him to have a prolonged stay at Brock's, Lebanon. The plan was to discharge him to the rehabilitation portion of Concourse, which is where he went, so that he can get skilled nursing care. And that is why I wish to point this out to your honors, is because it's very important. The correct expert on the rehabilitation side is a PM&R doctor. The correct person on the nursing home side is Dr. Honkinen, the geriatrician.
So you're saying that they didn't even meet their prima facie then? That's your argument. They didn't even meet their prima facie.
That is correct. But yeah, you know, there are things that you do tactically, Judge Owen, that you just leave alone. And now I have to reveal my cards. And that is that it is the defendant's doctor that is unqualified to offer opinions in.
How will you argue in your brief? Is that on the appeal? I mean,
I'm sorry, Your Honor.
Is that how the appeal was framed? I'm a little confused here because I didn't understand that was the. I thought the issue is whether or not you raised an issue of fact, not whether they made a prima facie.
Your Honor, that is exactly how the issue was framed by Justice Capella in the lower court. That is how appellant has framed the issue in not only their moving papers, but also in the reply brief and in our response. We directly, about a dozen times, say that you're getting it wrong. We are in the right part of the facility. We have the right doctor. You don't have the right doctor. And Dr. Root does not have to go through the process of laying a foundation because he's testifying within his specialty. Your doctor is not. So that's the first thing I want to point out to you, and there's a good reason for it. There are two separate.
Question, counsel. putting aside the defendant, where does your expert talk in his affidavit? He talks about being in physical medicine. Where does he talk about his experience dealing with patients with diabetes, whether he's ever dealt with patients with diabetes, and what his experience is in dealing with patients who have diabetes, who die related to diabetes? Where does he say that in his affidavit?
Your Honor, under New York law, when you're testifying within your specialty, and with diabetes being one of the most widespread diseases throughout not only this country, but throughout the world, it's like saying, what do you do when you have a headache? Everyone knows, not only a doctor, but regular people know that you take medicine.
As a physical medicine doctor, how would he know what did or did not cause, separate apart from the first issue about whether or not there was proper treatment, how would he know what the cause of death was, or what caused this patient's death?
Well, he says specifically so in his affidavit, and it's how every doctor is trained, every nurse is trained, any nursing assistant is trained. It's really very elementary medicine that can be understood and practiced by any range of physicians, like Justice Gonzalez pointed out.
So it's like medicine. It's like medicine 101. Would you coin it that way? Medicine 101.
Well, Justice Weber, it is medicine 101, and it basically and
I'm sorry, I stole that from my colleague. Here's
a little diabetes medicine 101. It's not good to have high blood sugar if you're a diabetic. It is not good to have low blood pressure if you're a diabetic. If you have low blood pressure, everyone knows to give the person orange juice. If you have high blood pressure, everyone knows to give the person insulin. What we know from this fact, and why Dr. Root, like anyone else, is able to testify to these facts is, and everyone agrees, when you have high blood pressure and you're a diabetic and you had a recent STEMI, which he goes into detail with in his affidavit, you run the risk of sudden cardiac disease because people who are hyperglycemic develop cardiac arrhythmias, and anyone who develops a cardiac arrhythmia who had a recent STEMI is at a greatly increased risk of dying from from the cardiovascular disease. And how did Mr. Almeida die? Exactly that way.
Counsel, I'm sorry to cut you off, but can you speak quickly about the sepulchre claim?
Oh, yeah, absolutely. Sure. So unlike, I think, the cases cited by my colleague, this is, look, you can slap a placard on that janitor closet and call it a holding room all day long if you want to, okay? But it was not a holding room. It was a janitor's closet. It was a laundry room. If you look at the pictures.
Counsel, if I can focus you a little more narrowly, does the rite of sepulchre simply mean the burial? Does the rite of sepulchre simply mean the casket? Does it simply mean the funeral home? Go there.
Under our law, there are two claims that can be brought under sepulchre. One is the collection of the body for burial. And the other one, which is what Justice Appellate indicated in his opinion that he was relying on, and that I would respectfully submit that this court should rely on, is how the body is handled or how the body is dealt with, and that's the Massara case. And you all know the facts of the Massara case, and this is more like the Massara case than it is with respect to any single other case in terms of a handling cause of action with sepulchre. And in fact, it's worse than Massara. And you know the facts, but I can get into them very quickly. But our case aligns with that Massara set of facts. The body was handled in such a way that it caused emotional harm to the family when they went to the mausoleum to view their loved one 18 months later. In our case, the body was handled in such a way that they were brought back, summoned back there.
Disinter the body in that case? Didn't they actually have to disinter the body in that case? Like bring it back up from the casket and unbury the body?
Well, the body was in the mausoleum.
Why is this worse than that? Just out of curiosity.
The body was in the mausoleum in the Massara in the one case.
Take it out, right?
I'm sorry?
They had to take it out. They had to unbury.
Well, my understanding is in a mausoleum, you can go to visit, but yes, because of the smell, that they did have to disinter the body. They did have to re-implant.
Why is this worse than that? I'm just curious. You said this situation was even more egregious than that one.
Well, because of,
more egregious than disinterring the body.
well, because in our case, as Dr. Root testified, the standard of care in a rehabilitation facility is to present the body in a clean room, in a clean bed, with all devices removed from the body and covered. When the family showed up, the body was naked with his eyes open, an endotracheal tube still sticking out of him, in a janitorial closet that was dirty and cramped with a plastic sheet.
Why it's worse than Massaro? That's what you just said, that this is a worse situation.
I think it actually is. I think that at least in the Massaro case, the family had the opportunity to grieve at a time when emotions are most high, and then buried their loved one. And then 18 months later, they see that this has occurred. That is unfortunate. It's awful. But this family who just lost their loved one suddenly was presented with this individual under those circumstances. I find it actually quite.
Thank you, counsel.
Quite more
Thank you very
appalling.
much. Your time is up. Ms.
Thank-
Henderson, you have a minute, I believe. Yes.
Yes, Your Honor, just very quickly, I first want to note that I believe it was Justice Kern is correct that plaintiffs in their respondent's brief never argued that we did not meet our prima facie burden. In fact, the only thing they said about our burden was that we didn't meet our burden because they raised issues of facts in opposition, and that's respondent's brief, page 7 to 8. That, of course, muddles the movements and non-movements burden, and that was never raised. Also, plaintiff is bringing up this brand new theory about the difference between rehabilitation standard of care and nursing standard of care. I have never heard that distinction before until now, which is quite unsurprising given that plaintiff throughout has raised new theories of liability in opposition to summary judgment and now apparently an oral argument. I would also argue that as to the sepulcher claim, this is absolutely nowhere near the facts of Mazzaro. This is absolutely nowhere near the facts of any of the cases in which the body was interfered with in a way that violated the right of sepulcher. There are numerous cases that I cited in my brief where the facts are horribly upsetting. I would note the Roach case where you have Howard Stern on the TV show playing with the decedent's ashes, and that was not found to violate the right of sepulcher. You have Shipley out of the Court of Appeals, where the medical examiner retained the decedent's brain without the parents' knowledge, and the decedent was a high school student whose classmates then went on a field trip and saw the brain in a jar. That was found not to violate the right of sepulcher. So there is, at minimum, the right of sepulcher claim has to be dismissed here. I would also note that the public health law claims also have to be dismissed because plaintiff offered no opposition to our prima facie showing with response to those claims on summary judgment.
Thank you very much. Thank you both. Next matter is Salzano versus Air and Liquid.
May it please the court, I'm Nicholas Herzler and I represent Kaiser Gypsum, the appellant. Your Honors, this is a case that turns on a 44-year-old hearsay statement, which was accepted by the lower court as a present sense impression. However, neither of the elements of that exception, that hearsay exception, are met under the circumstances. There has to be a contemporaneous showing that the person who made the statement made a contemporaneous observation of what he was saying. In this case, we don't know anything about what Napoli was supposedly observing at the time. All we know is from the very limited fragment of testimony that we have, which is the only link between Kaiser Gypsum in this case, is a statement that, which is in the record at 318 and 319, where he says, I was told Kaiser when we were working with the compound, and he says Tom Napoli. So that's all that we have. We don't have anything from Napoli or from anybody else saying, sure, Napoli saw a label and said this is Kaiser Gypsum or anything like that. For all we know, Napoli heard this from somebody else. For all we know, he saw a Kaiser Gypsum salesman outside. For all we know, he simply made a guess that it looks like a Kaiser Gypsum product. So it's not a contemporaneous, that element is just simply not met. Even if it could somehow be met, there's no corroboration here because the only argument that the plaintiff made in the lower court was, okay.
Counsel.
Yes. Hello?
Is there any representation anywhere that Mr. Napoli is deceased or unable to be found?
I believe that I believe that he is, Your Honor, but there isn't an argument.
He is what? Unable to be found, or he's deceased? Do you have your
Honor,
phone on? There's an echo.
I'm sorry about that, Your Honor. I don't know why. I can try to alleviate it.
It's fine.
It worked. Oh,
I think because we have too many open mics on, but it's
Maybe it'll help if I use the earphone.
thank you.
Is
So
that,
if you
is
could
that
just
any?
indicate, is he presumed dead or is he unavailable? Mr. Napoli, that is. Oh, he froze.
Yeah, you froze.
Your Honor, I believe that's because plaintiff hasn't brought that up plaintiff has not argued that would somehow make a difference in terms of, whether the statement is admissible or not. The plaintiff is only arguing that, it's a present sense impression, and there's not an element that's disputed in terms of whether he's available or anything like that. They're just saying it's a present sense impression. That was the only reason that the lower court, held that the exception applied. And I'm just saying that, as far as what the only description that was given was that the joint compound was white and it came in a bucket that was either 3, 4, or 5 gallons. And the witness, Mr. Salzano, Tom Salzano, did not know whether there was a label on that, any kind of description of the bucket other than that. And they said, well, a joint compound, because that matches a Kaiser gypsum product, it's a white mud-like consistency of the product, and it comes in a plastic bucket that's 3, 4, or 5 gallons, then it must be Kaiser gypsum compound. And all we're saying is every type of joint compound has that same description. It's all white. Tom Salzano at 299 and 297, and then 328 of the appendix, identified 2 other brands with the same exact description. And the court, I think, can take judicial notice that every other brand has the same description as well. So that's like saying, this is ketchup, this is Heinz brand ketchup because it was red and it had a smooth texture. Every other brand of ketchup has the same description. So all we're saying here is that the plaintiff failed to raise a genuine issue of fact as to any connection between Kaiser gypsum and the alleged exposure. And unless the court has any questions about that, I think I'll reserve time. I have 2 minutes in rebuttal.
Any questions by anyone? No? Thank you very much, counsel.
Jason Weinstein for the Salzano family. At the outset, Your Honors, there's not even a requirement for this court to actually make a determination regarding whether Justice Mendez properly applied the present sense impression, because there's clear case law from this department that regardless of whether evidence brought forth by the party responding to a summary judgment motion is admissible or inadmissible, it can be used in opposition to the motion. So regardless.
So counsel, I just want to ask the question that Justice Gonzalez asked. Is Tom Napoli, where is Tom Napoli? Because he's the best person for this. I mean, he works right beside the plaintiff, right? So is there, that's just a question I had. Where's Tom Napoli?
Unfortunately, Your Honor, I don't actually know the answer to that question.
Good enough. Fine, that's good.
I'm sorry, Justice Kern has a question?
Yeah, you said you were talking about you can use hearsay evidence, but the rule is in conjunction with admissible evidence. So I wanted you to articulate for us what the admissible evidence is that supports your claim that product identity.
Well, the admissible evidence is the deposition testimony from Thomas Salzano, who worked alongside his father. And there's no granularity requirement that every fact established by the plaintiffs.
If his was good enough to be the admissible, it would be good enough without the inadmissible. If he had a clear enough testimony to create that issue of fact, you wouldn't need the hearsay testimony. So I think when they say you need admissible testimony in conjunction with inadmissible, the admissible has to be enough to create the issue.
Well, I think that's what I would dispute, Your Honor, in terms of getting so granular that in addition to any potentially inadmissible testimony, that there had to be first the clearly admissible testimony. In other words, there's the admissible testimony that plaintiffs presented from Thomas Salzano, but that doesn't mean necessarily that every single fact adduced by plaintiff need to have both admissible.
So how did Thomas Salzano specifically identify this compound as being a source of the asbestos exposure?
Well, he was asked the different ways in which his father was exposed to asbestos. He mentioned joint compound. And in fact, before even getting into how did he know whether the specific joint compound at issue was Kaiser, he identified, and this is page 144 of the record, he said Kaiser was big, he used that. And then on page 151, he said, I think I had mentioned Kaiser. And that's in response to the various brands.
He could not distinguish it from any other compound. He had no knowledge, personal knowledge of whether his father had used it. Right? Is that correct?
Well, he had the knowledge in terms of what he learned from what he said that he learned from Mr. Napoli.
Right. So we're back to Mr. Napoli. So what I'm trying to determine is exactly what knowledge Mr. Salzano had that was unique to him. What's specifically asked to Mr. Salzano and not depending upon anything that Mr. Napoli told him?
Well, he had the knowledge that his father worked with various joint compounds. He had the knowledge of what the compounds looked like. In other words, what kind of containers, how they looked, the consistency.
White. And then
when asked,
it was white pre-mixed with a consistency like mud or peanut butter, which I don't know that again would distinguish it from any other compound. He couldn't recall the color of the bucket or the lid, whether it had a logo or handled, etc. So again, I'm not really sure what his specific knowledge would be that would lead us to believe that it was the defendant's compound.
Well, in terms of, no, it's a fair statement to say that the various types of joint compound were of similar color, of similar consistency. And then in terms of how did he know that Kaiser was one of the brands, he did mention that he was told so by Mr. Napoli at the time. Now, in terms of the two requirements for a present sense impression, the contemporaneous requirement and the corroboration, they're both not exact. And the cases that address it from this court never apply very specific requirements in terms of what is contemporaneous and what is corroboration. Now, as described by Mr. Salzano, he mentioned that he was told this by Mr. Napoli as they were working with the particular product. So in terms of contemporaneousness, he mentioned that it was.
So what did it have to do with his observation? The fact that he told him, what it had to do with anything he was observing at that moment? What is the observation that is connected to?
Well, that unfortunately, decades later, we don't have. There was no testimony as to exactly what was occurring when Mr. Napoli made that identification for him.
At the heart of a present sense impression that you're talking about, hey, I'm observing this, I'm seeing this right now, and that's why it's present sense.
That's true. Although what Mr. Salzano testified is that he was told by Mr. Napoli at the time, presumably from the context and certainly as judging the inferences that can be drawn for an opponent of a summary judgment motion, the inferences is that Mr. Napoli told him that as they were handling this product. Otherwise, the identification plainly wouldn't make any sense. It would simply be nonsensical.
Yeah, so even if you could make out the present sense impression, you need corroboration for present sense. What's the corroboration?
Well, the corroboration again was Mr. Salzano's description of the product. And sure, that may also apply to other products, but it did apply to the Kaiser Gypsum product. And there's no inference or there's no suggestion from opposing counsel that this is not what the Kaiser Gypsum product looked or felt like in terms of the consistency. Even though the description may match other products, it certainly did match the Kaiser Gypsum product.
Any additional questions? Thank you very much, Counselor.
Thank you.
You do have 2 minutes on rebuttal.
Your Honors, I think that the court understands my argument. And so unless the court has any questions for me, I intend to rest on my brief.
Any questions? Thank you very much. Thank you both.
Thank you.
The next matter is People versus Christopher Rodriguez.
May it please the court, Jake Walter Warner from Mr. Rodriguez Pro Bono Counsel alongside Legal Aid Society. Mr. Rodriguez was denied his right to a fair trial. The people were erroneously permitted to enter extensive evidence, propensity evidence, to prove an issue, intent, that was not at issue at trial because it was obvious and that Mr. Rodriguez did not contest. Given the other evidence of Mr. Rodriguez's guilt was not overwhelming, the decision to admit the propensity evidence was not a harmless error. The main case that the people rely upon for the idea that it was appropriate to enter Molyneux evidence of intent in this case is People versus Espinal, a decision of this court from a few years ago.
Well, in terms of intent, counsel, your client did place the issue of intent. There was an issue as to intent. I mean, he did testify as well as he made numerous statements which were inconsistent, but he did state that he entered the building. He didn't live in the building. He acknowledged he did not live in the building, and he stated that he entered the building because he was going to smoke marijuana. So again, why does that not place his intent to commit a crime under the burglary statute? Why would that not allow the people then to introduce testimony as to his prior convictions for burglary?
Justice Weber, the only intent that was relevant was the intent of the person on the fire escape at the time they tried to enter the building. This was the people's sole theory of the case. In fact, they opposed an application to include trespass as a lesser included charge because they said their sole theory was that he was the person on the fire escape. The only time that intent matters, and this is according to People versus Gaines, a Court of Appeals decision, for burglary is intent at the time that someone attempts to enter a building. Here, the intent of the person on the fire escape was obvious, and you don't have to take my word for it. The people themselves said so in their summation. And
but your client did not admit to being on the fire escape.
Exactly.
He denied being on the fire escape.
Exactly. And that's how this case is different from Espinal. He denied that he was the person who committed the actus reus trying to get into the complainant's apartment. In Espinal, the person admitted they were on the fire escape, but denied that they were there with the requisite mens rea to commit a burglary. They said that they were there for they said that they were there, but didn't have an intent to commit a crime inside the building. That's the exact opposite.
Counsel, this is Judge Owings. So, counsel, this is Judge Owings. So it sounds like from what I recall, it's an identification issue, right? It just boils down to that. He's saying that wasn't me. Whoever it was, you're conceding, he's conceding, the defense conceding, whoever it was that was on the fire escape was committing burglary, but that wasn't me.
That's exactly right. That was his only defense. He never contested that whoever was on the fire escape had the requisite intent. And you, again, just look at the people's summation where they said, you don't engage in that type of conduct trying to get into a stranger's window if your intent was not actually to commit a crime therein. So that's not an issue. That's an accurate description of what was at issue at trial.
Are you also making the alternative argument that even if it was not an error to allow in evidence of these crimes, it was an error to allow it in the extent of the evidence about the crimes? And that's an alternative grounds for why the conviction should be reversed? And can you
Yes.
say that?
That's exactly right. There are two independent grounds for why this conviction should be reversed. First, because the evidence shouldn't have been allowed in the first place. And second, because the quantity and nature of the evidence was highly prejudicial, so much so that it deprived him of his right to a fair trial. Just briefly, again, on Justice Owings' point, there are two very persuasive decisions here from the second and third departments, Wright and Hunter, that are very similar to this case. In those cases, the people's main testimony was an eyewitness who saw someone trying to break into a residence. The defendants defended on the basis of saying, that's not me. I wasn't the person who did that. But the courts allowed the people to enter evidence of intent on Molyneux, and the courts in the 3rd Department and 2nd Department reversed and gave the defendant a new trial, saying that these persons' actions were not equivocal. They're not the type of actions where you need to have Molyneux evidence.
The only thing is that the complainant, the resident of that apartment, did give a description of the individual who she saw on the fire escape, and that description matched your client once he was actually arrested in the courtyard. So although he was claiming that, I guess to some extent it was not him on the fire escape, there was evidence to support that it was him who she saw on her fire escape, tinkering with the air conditioning unit.
So 2 responses to that, Justice Weber. First, my client was unequivocal that he was not the person on the fire escape. He denied it outright. He denied it when the police interviewed him at the time. He denied it when he testified on the stand. What you seem to be driving at is that the error wasn't harmless. There was sufficient evidence here to convict him of a crime. But here you have to look at what the Molyneux evidence was that was entered against him. It wasn't simply some stipulation saying that he had been convicted of burglary.
So what I was driving at was that there would be a basis for the people to perhaps argue that they should be able to introduce testimony as to intent. That his intent was not actually to go in, obviously, and smoke marijuana, but his intent was to commit a crime, remove property, and the basis of a burglary, and in that he was the individual who was on the fire escape.
Well, that's exactly what the people's argument is that he was the person on the fire escape and that they should be able to introduce intent to illuminate what that person's mindset was. But you look at Wright, you look at Hunter, you look at Court of Appeals cases in McKinney and Leonard, and it's clear that Molyneux evidence on the issue of intent can only be admitted if the action that someone is testifying to is equivocal, or is the type of action that could be innocently or inadvertently committed. What the person on the fire escape was doing was not the type of action that could be misinterpreted as somehow innocent.
Oh, counsel, this is Judge Owing. So you, correct me if I'm wrong, but is your argument then simply that when the eyewitness got on the stand and testified that the defendant was the individual on the fire escape, and then he gets up and said, that wasn't me on the fire escape, that was it? That was all that had to be decided by the jury?
That's exactly right. The only issue for the jury was deciding, was Mr. Rodriguez the person on the fire escape?
Therefore, the Molyneux ruling the court should not have granted the people's granted, or at least permitted the Molyneux, you know what I'm saying, the Molyneux ruling.
That's exactly right. And if you look at the evidence that the Molyneux evidence they actually submitted.
Well, counsel, we can look at that on your rebuttal. People?
Sure. Thank you.
Thank you, Your Honor. It's Michael Yetter for the people. The proof of the 2 prior burglaries was probative of defendant's intent and to refute his explanation for his presence where he was found in the court on the steel platform on the inside of or just outside of the building. And that's why Justice Burke admitted that evidence, both to prove intent.
Counselor, but isn't there an anomaly in admitting evidence from 2010 and 2011, 2 burglaries right next to each other, in a case involving a burglary in 2017? I mean, you had testimony from a victim, an earlier victim. You had testimony from an officer. You had surveillance tape that was shown, all in reference to past criminal conduct, where the defendant even writes down, "This is me," on a still from a videotape. Isn't that highly prejudicial to the existing jury who's trying to figure out, is this the guy? Is it not the guy? Is the victim here testifying accurately? Is she not? I mean, how do these things, how are these prior acts, these prior convictions, not absolutely prejudicial?
Well, Your Honor, I agree that they're prejudicial to some extent, as all Molyneux evidence is. However, I think one thing that's important to remember here is that the people's initial application involved 4 prior burglary convictions and 2 additional arrests. And what Justice Burke did was he limited the admissible evidence to these 2 particular burglaries, both to reduce the sort of overpowering effect that it could have on the jury from a huge amount of Molyneux evidence. And he wanted to cut down on the number of witnesses because some of the burglaries related to other residences, which would have required other witnesses.
Sorry. This is Judge Owing. I'm sorry. But I'm trying to understand this. According to the appellant's argument, he's saying, look, the Molyneux application should have been denied because the only issue here was whether or not the defendant was the guy in the fire escape. And I asked the question, when the eyewitness testified that the defendant was the individual on the fire escape, and then the defendant gets up, putting aside all the other explanation he gives in terms of why he was in the building, and testifies that I was not the guy on the fire escape because I was downstairs smoking a joint. It's less about the intent and more about identification. And at that point, you don't really need Molyneux, right? I mean, you don't need a Molyneux evidence at that point. Because he's just saying, that wasn't me. I agree that the guy that was on the fire escape was going to commit burglary, but that's not me. So why would you need intent then?
Right. Well, I guess I would just say this is the first, in his appellate brief, this is the first time defendant has taken this position. It, of course, was not his position at the trial below. He opposed the Molyneux application, yes, but on the grounds of, it being being propensity evidence.
Right.
Now,
and of course, the Molyneux decision is made prior to the defendants taking the stand, and we don't know what the defendant would have ultimately testified to because the Molyneux application was based upon what the people were going to present on their direct case, not knowing what the defendant is going to testify to and whether he would admit to being on the fire escape or not. But my issue or my question is, you talked about the fact that the people initially wanted to introduce 4 burglaries. And, I recognize this occurred in 2018. And so we're talking about 2 prior burglaries, 2011 and 2010, which was within the 10-year period of time, which we normally look to when we look at Molyneux, we look at Sandoval, we look at about 10-year period of time. And so this was within the 10-year period of time. But the issue here is that, there was so much evidence as to those 2 burglaries that was admitted in terms of the surveillance video, the police officer, the arresting police officer, the tenant of one of the apartments, the still photographs that were introduced, the video showing the defendant kicking the door down of the, kicking the door in of the building. So at some point in time, do we cross the line from intent and move into propensity?
Well, I think there's of course a risk of that happening, Your Honor, and that's why I believe Justice Burke was so careful here and adamant in
and
issuing.
I forgot to mention, I'm sorry, that at some point in time, he was going to allow the people to introduce the actual factual allocution, the plea allocution that the defendant made from, I think, the 2011 conviction. So again, it's a balancing between probative versus prejudicial, but at some point in time, I'm wondering, do we tip it towards too prejudicial and too much to propensity?
Yeah, Your Honor, I agree that's always the balancing act, but I believe Justice Burke here, he gave the limiting instructions after each Molyneux witness testified, specifically instructing the jury that they can consider the evidence in the exhibits submitted for the sole purpose of intent and for no other. With respect to the plea minutes, the judge, after he had reviewed them, said, I looked at these and they don't contain anything pertinent to intent in this case, so I'm going to modify my ruling and I'm not going to allow the people to read or introduce these plea minutes into evidence at this trial. So I think he was, balancing the issues that were here in this case. And of course, these jury charges, the jury is presumed to listen to them and to follow them. There was no, objection or request from defense counsel that for anything additional or a complaint that the instructions were not good enough. And we also think that defendant's guilt was proven beyond a reasonable doubt in this case. And that the issues or credibility issues raised by the identification, specifically the conflict between the complaining witnesses and the officer's testimony at trial, presented an issue for the jury to resolve. And if the jury, in fact, had a reason to alter the verdict based upon the complaining witness's testimony, they were perfectly able to do that. But I think when you consider it in connection with all the other evidence in the case, particularly the prompt show-up identification, defendant's presence immediately near the scene of the crime, there was ample support for their verdict. And unless your honors have any other questions.
Thank you so much. Thank you very much. Counsel, you have a minute.
Thank you. The Molyneux evidence that was entered in this case was far more prejudicial than it was probative. Again, the issue of intent was hardly probative because it was obvious from.
So we're beyond the intent. Now
Yes.
we're at the issue Justice Kern had asked you about previously in terms of the amount of the evidence that was submitted as your second argument or your alternative argument. So did the curative instructions, did those cure, or I'm sorry, the judge's instructions cure any issues as to prejudice?
No, Your Honor. This court in Foster said that someone's right to a fair trial was violated when propensity evidence was entered against them. And in that case, the propensity evidence was one instance of someone committing a subway pickpocket right before right after the instance of which they were actually convicted. Here we had 3 witnesses who testified solely about his past crimes from 2010, 2011. Those witnesses some of them gave heart-wrenching testimony about how they were forced to move out of their apartment because they were so scared of the defendant. There was dozens of photographic exhibits, again, solely about his past crimes, and a videotape of him committing a similar crime, but not the crime that was at issue. And in Foster, this court said that when propensity evidence is so similar in nature, it creates a presumption that's almost impossible to overcome. And that's exactly the sort of prejudice that Mr. Rodriguez faced here. And
Thank you so much, counsel. Thank you very much.
Thank you.
The next matter is Robinson versus Great Performances.
Good afternoon. May it please the court. Lois Traub, Elenoff, Grossman, and Scholl for the appellants. Great Performances artists as waitresses, Lisbeth Newmark, Dean Martinez, and Linda Abbey. We are asking the court to reverse the lower court dismissal of the third-party complaint seeking indemnification between caterer Great Performances and staffing company Kensington on a motion to dismiss as premature and as New York labor law does not preclude contractual indemnification.
Counsel, why shouldn't we follow Herman and Gustafson and also Delphi, which is the 4th Department, which all hold that there is no right of contribution or indemnification for employers, regardless of the status of the party from whom they seek the contribution? Why shouldn't we follow those cases and have the same approach in this case?
Your Honor, because those cases are entirely distinguishable. In Gustafson, the issue there was shifting liability from the employer, Bell Atlantic, to the employee who was characterized as an independent contractor, and in that case forced essentially to have enter into an indemnification agreement. That is not the case here. We have an agreement between 2 commercially savvy entities. Kensington, which has been in the hospitality staffing business for 31 years, freely entered into this agreement.
Let me
It is not,
language.
I'm sorry.
Counselor, let Justice Kern.
Broad. I mean, I understand you're trying to make the distinction, but that's not a distinction that's made in either of those cases in terms of what the reach of the lack of right of contribution and indemnification is.
Well, it is an important distinction because it is not the law prohibits shifting indemnification to an employee. In that case, it was.
But isn't there explicit? What I'm addressing is the explicit language in Herman that says, regardless of the status of the party from whom he seeks contribution. So it's explicitly saying that it does not matter who he's seeking the contribution from. If they're an employer, they can't do it. So that's why I'm a little confused by how you're trying to distinguish it.
I see. Thank you, Your Honor. Herman was a case that arose under the FLSA only. This is not a case involving the FLSA. It is different. It rises under the New York labor law, section 196D.
What about Gustafson and Delphi? Gustafson refers to both the New York labor law and the FLSA, and Delphi clearly refers to the New York State labor law. Why should we not follow those line of cases?
Well, in Delphi, first of all, that's a Fourth Department case, and you're not bound by that precedent. It's not stare decisis in this department. But as another matter, and more crucially, that was not a contractual indemnification case. That was a common law indemnification case. What this case involves is an agreement, a contract between two entities. And Kensington is commercially savvy, as per its website.
Counselor, and I know you keep saying the commercially savvy, but all of those cases do not make a distinction or do not hinge on the fact that it's not contractual, is contractual indemnification. The language in all of them is very broad. It refers to no right of contribution or indemnification, and it doesn't make any distinction between common law indemnification, contractual indemnification. So if there's no right of contribution or indemnity, what does it matter if it's contractual indemnification or common law indemnification or any kind of indemnification?
Well, common law indemnification is what is implied, right? And in contractual indemnification, there is a contract. There's an agreement between the parties. In this case, two employers, because they're essentially joint employers over the staffing company employees.
Counsel is referring to the language we started at the beginning, that the status of the party from whom contribution is sought is irrelevant. I know that's what you keep wanting to come back to because there's a contractual agreement, but if we follow the language in Herman and Gustafson and Delphi, then it doesn't matter who the agreement is with. The point is that you're not supposed to be allowed to go seek that indemnification regardless of who you're seeking it from.
That is, I think, an overbroad reading of those cases. And I think that there is a line of cases that have allowed contractual indemnification in New York, in the Eastern District, which is Baganis, Bogosian, and Amaya. And in those cases—
do any of those cases try to distinguish or discuss Herman, which is a Second Circuit case and obviously controlling on them? How do they do any analysis whatsoever where they say, well, Herman doesn't apply because X, or Herman doesn't apply because of Y, or they just don't discuss Herman?
I believe there's a footnote involving Herman and other cases in one of those cases. But I think because they did not, many of them did not address Herman directly because that's an FLSA case, and this is a New York labor law case.
Thank you, counsel. You have time on rebuttal.
Okay, thank you.
Good afternoon, Your Honors. If it please the court, this is Eric Milner, and I'm appearing for the respondent, Kensington Events. The appellant, putting aside the rest of the appellant's arguments, the appellant seems to continue to focus on the fact that they are that they may not be the employer, And by their own documentary evidence that they have submitted, they are the employer here. And we don't even have to get into what the status of what party is. That they are Barry Robinson's employer. They were alleged to be his employer, and they then submitted their own affidavit in support of their own motion to dismiss, in which they essentially admitted to the facts that would establish Barry Robinson was Great Performance's employer. So I don't know how it is that they're attempting to seek indemnification when the case law that your honors are very familiar with is clear that contractual indemnification is just simply not permissible. The footnote that I think my colleague was referring to is out of the Garcia case, and in that case, a contractual indemnification case such as this was dismissed on a pre-answer motion, and the court, in a footnote, acknowledged Paganis, Bogosian, and Amaya, and said that they did come to a different result, but the court noted that in none of those decisions did they even mention Herman or Gustafson. So presumably those decisions were decided incorrectly.
Let me interrupt and just ask you a completely separate question. They make an alternative argument that if they're found not to be an employer, then they should still get to seek attorney's fees and costs under the indemnification agreement. What is your response to that argument?
Sure. My response to that would be that the indemnification agreement is still void as against public policy. So this isn't like the Espinal case that they cited, where, I believe it was the plaintiff sued Time Warner and then Time Warner sought indemnification from, I believe, Highland, and Highland had an indemnification agreement with Time Warner that said that if they agreed to indemnify them if for any actions arising out of Highland's work. And there was no question that the lawsuit arose out of the permit that Highland was working under. And then there was no question that Time Warner was ultimately found not liable. However, that indemnification agreement is valid. That's a valid indemnification agreement for a subcontractor to indemnify a contractor from simple claims made against them, whether they be for negligence or I'm not sure what exactly that claim was actually for. But this is still an agreement to indemnify for a violation of federal and state labor law, which is just simply not permissible. It violates public policy.
Any additional questions?
Something very basic, because I don't know that I understand your answer. If the defendant is not found to be an employer, then can it be held? You wouldn't agree that it should be indemnified?
That's correct, because you can't indemnify. You cannot provide indemnification for a labor law 196D violation. It doesn't matter if the claim made against them is without merit. They have no right to seek indemnification of the claim from someone else. And I think in any event, the documentary evidence, it's irrefutable that Great Performances is the employer under the hospitality wage order.
Which is a different issue.
Well, yes.
Yes.
Anything else? Thank you very much. Ms. Traub?
Yes, Your Honor. Going back to the premature argument here, which is an important one. The lower court incorrectly found that a determination that Great Performances is not the employer would obviate Great Performances' need for indemnification from Kensington. And that prevents Great Performances from seeking to recoup its defense costs and attorney's fees.
Counsel, what is your specific response to the argument just made by opposing counsel that if these type of clauses are void against public policy, that you can't have a clause which allows indemnification for wage claims, that even if you're found ultimately not to be employed, the clause itself is invalid, and therefore that obviates your right to seek indemnification for attorney's fees.
Well, I disagree. They would, first of all, one has insurance sometimes for these cases, and there are insurance companies that assume the defense costs, which is permissible, for example. And a Supreme Court justice, when confronted with the same issue at the same time during the proceeding in Robinson versus Foremost Kosher Caterers, held that for the sake of fairness and judicial economy, the CPLR allows third-party actions to be commenced before they are technically ripe. And in that case,
that's not the issue I'm asking. That doesn't go to the issue of whether we should hold or not hold as a matter of law. That if these agreements are void as against public policy, then they're void ab initio, and you never get to the thing you're arguing about. That if you're found not to be an employee, you get counsel's.
Well, if agreements between two employers or joint employers to shift liability would not be against public policy under 196D.
Isn't that exactly what Herman and Gustafson hold?
Well, as I said, Gustafson was really a case where the attempt was to shift liability to someone who was an employee by creating this sham independent contractor agreement. I mean, Gustafson was a limousine driver, was a driver for Bell Atlantic. That's very different from two commercial entities entering into an agreement to shift liability.
Thank you, Counselor. I'm sorry, your time is up. Thank you very much.
Thank you.
Thank you, Your Honor.
Take care. Last case for argument, Vega versus the City of New York.
Thank you. May it please the court, my name is Jameson Davies for the City Appellant. Supreme Court's order denying summary judgment to the city should be reversed. Here, it's undisputed that there was no prior written notice to the city of the street cuts on which Vega alleges she fell. The only issue is whether the evidence created a triable issue of fact as to whether the city or its contractor affirmatively created those cuts, and there is simply no evidence in the record supporting Vega's theory. The only evidence that the Supreme Court and Vega point to is a contract for construction that took place 64 feet away from the center block where she alleges that she fell. And as this court and the Court of Appeals have held, that's just not kind of evidence sufficient to support the inference that the city's contract itself resulted in those cuts. Not only that, the city's employee testified that those were not the kind of cuts that would be made for this kind of contract, and that DCP, which was the sponsoring agency, would not have made those cuts for any of the construction projects with which he was familiar. So nothing really supports the inference that the city or its contractor could have been responsible for these street cuts. And it would require just speculation to suggest that it was otherwise. Unless there are any questions, I'm happy to rest on that argument.
No, you also have a minute in rebuttal. Thank you.
Thank you, Your Honor.
Yes, you may proceed. I think you're muted.
Sorry about that, Your Honor.
Okay.
Good afternoon, Your Honors, and may it please the court. My name is Thomas Satilli on behalf of Respondent Renee Vega. The Supreme Court properly denied the city's motion for summary judgment based on two major issues: the spatial and temporal proximity of a major reconstruction project to the roadway defect that caused my client's injury. Now, based on that spatial and temporal proximity to the major reconstruction project that the city—
So 64 feet away, isn't that pretty far, 64 feet? I mean, there's no dispute anywhere I saw on the record that there was a 64 feet separation between where the catch basin was being built and where the plaintiff had her accident. So isn't that, pretty big space?
While you're correct, Your Honor, that it is not disputed that there's 64-foot space between the defect and the zone in which the permits authorized work, we submit that is actually not a large enough space to invite metaphysical speculation as to whether contractors did conduct work in this area, and that taken in conjunction with the 4 permits pursuant to which it is undisputed that work was being done in the area, as the Supreme Court held on page 8 of the record, was sufficient to create a triable issue of material fact. Now, as to the issue that you honed in on here, Your Honor, as to whether the city was actually doing work in the precise location, the city relies on the testimony of the city engineer, Mr. Modi, to demonstrate that the city was not doing work in this location conclusively. And we submit that that is not sufficient to show conclusively that the city was not doing work in this location, because Mr. Modi testified at his deposition that he had no experience ever overseeing work on Columbia Street and did not personally oversee the work at the accident location.
Counsel,
therefore, he is not credible.
What about the fact that he states in his affidavit that in making that opinion that it was 64 feet away, he was relying on the contract drawings, specifications, and other documents to support his opinion as to the distance?
He may well have been relying on other documentation to support his assertion, Your Honor, but the assertion is fundamentally incredible, and the credibility has to be determined at trial because he did not have firsthand knowledge of the defect. Now, this credibility is precisely the fodder for cross-examination at trial, and is why—
You acknowledge there's no dispute about the 64 feet? So isn't the job for us just to determine whether 64 feet is too far or is not too far? That it's not really a matter of whether he had enough information, because no one's disputing the 64 feet, right?
That's correct, and that's a different way to view it, Your Honor. But I would take the argument that this was based on speculation. I would take it the other way. This is in fact logical inference that pursuant to 4 permits that the work may have been done within the area. 64 feet is not a majorly large area.
But what is that based on? That the work 4 permits means that the work may have been done in the area? I don't know. How do we reach that conclusion?
Well, work was done in the area pursuant to these permits. The area is Columbia Street, near the entrance of Luther Gulick Playground, between Broome Street and Delancey Street. We have—
Right. We're talking about the area that the plaintiff tripped over. That's the area that we're talking about. So I'm not really sure what your argument is, that because work was being done in the general area, and we have 4 permits in the general area, that we know that where the plaintiff, the area that the plaintiff tripped on, that work had been done specifically by the city in that area.
I'm sorry, Your Honor, you broke up there at the end of the question. I didn't hear you.
I'm not understanding your argument as to how, again, we know that the city was involved in any construction or any work being done in the specific area that the plaintiff tripped.
Right, Your Honor, my contention is that there's an issue that remains to be tried as to whether the work was in fact not done in the area, and the standard is whether there's a reasonable basis to conclude that work might have been done in the area, and that is the standard that was applied here by the Supreme Court, and that is precisely the purpose of
Counsel,
trial. Can
I twist this in a different way?
Sure.
So Mr. Modi testified that he wasn't familiar with the cut in question, that it's not used by the city, and he testified that he wasn't familiar with the rectangular grid pattern that was etched into the roadway. But at the same time, we know that in addition to the 4 permits that were issued to the city, there were 2 permits issued to Con Edison.
That's right.
Relative to this area. So given that testimony from Mr. Modi, and nothing to say that the city did actually use this type of grid cut, don't we have like a dead end?
Well, I'll answer that question in two parts, Your Honor. First, Mr. Modi's testimony was essentially, because I'm unaware of this happening, it didn't happen. Now, that is enough of a ground for cross-examination at trial of Mr. Modi as to his credibility. Second, Con Ed is not an appellant in this matter, but that is also an issue for trial as to whether Con Ed or the city did in fact create this type of deliberately made concrete cut mart into the asphalt. So all these 2 points that you've honed in here on, Your Honor, precisely underscore the need for a trial here in this case.
Thank you very much. Anything on rebuttal?
I'll just be very brief. I'll make 2 quick points, Your Honor. First, as to Mr. Modi, the issue is not the credibility of his testimony. He was testifying based on the documentary evidence, which was undisputed, and his experience in overseeing these kinds of projects. And based on the plans and the drawings, he was able to conclude that they wouldn't have made a cut 64 feet away from the corner where the work was to take place. And as to the physical distance, I would just point this court to its decisions in De Silva and Flores. I think in Flores, the work was actually taking place on the opposite corner, which is much closer than this 64 feet away mid-block, and the court held that that was not enough to support an inference that the contractor had been doing the work. It might be different if the scope of the project was different, but given that this was a catch basin to be installed on a corner, and no one suggested it would have extended any further than that, the undisputed evidence shows that the city was entitled to summary judgment. Thank you.
Thank you very much. Thank you all. That concludes the oral arguments for today, March 30th, 2021. Thank you very much. Have a good day.